Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time. Maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case would be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
All rise. Court's now in session. The Honorable Terrence R. Kevin presiding. Please be seated.
Good morning. Okay, good morning. We're here on our November 7th, 2022 criminal docket day. We'll begin with a name I can't pronounce. Naronsky. Morning, Mr. Allen.
She's approaching with the interpreter, Your Honor.
Okay, good morning. Would you please announce the case?
Your Honor, the case is Ms. Milana Noronskaya, and I apologize if I got that wrong. It's case number 21-2817. Your Honor, I believe I've spoken with Mr. Allen, and we're still in the process of trying to work this one out. There's still a chance that we might. We understood that this might be the last continuance, but at this time, I believe we're asking for a joint continuance for one last time.
That's correct, Your Honor.
Very good. Court will note the last continuance in the clerk's minutes, and we'll continue it until pre-trials on 12/27, 9 a.m.
Thank you, Your Honor.
Thank you.
I'll be in touch with you.
William Garcia. Good morning.
Ricky Dyram on behalf of Mr. Garcia, 22 CF 944. Judge, he's going to be evaluated for Veterans Treatment Court. There's a waiver on file, Judge.
Okay.
So if we can continue his case one cycle, he's already provided me the documents for it.
Okay, so we'll come back on 12/27, 9 a.m.
Thank you, Judge.
State's okay with the continuance?
Yes, Your Honor.
Taryn Schaffner, Mr. Dees. Good morning, Mr. Dees.
We've reached an agreement at this time in exchange for a null processing counts 1, 2, 5, and 6. Mr. Schaffner will enter a plea of no contest to counts 3 and 4. The agreement as to count 3 will be a withhold adjudication, 6 months of probation, substance abuse evaluation and treatment if recommended, $250 in court cost. Count 4 would be adjudication of guilt, credit for time served. Judge, we have it written out. May I approach?
Please.
Judge, that's the offer. The victim declines to prosecute, so the null process are based on that reason.
Very good. Mr. Schaffner, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard the your attorney state the terms of the plea agreement. 4 of the counts will be null process, basically dismissed by the state. You can put your hand out. And the only 2 that are remaining are count 3, possession of marijuana and possession of paraphernalia. And there'll be a withhold of adjudication as to count 1 and an adjudication of guilt as to not count 2, but
Would be count 4 in the information.
count 4, possession of paraphernalia. That would be an adjudication, withhold on the possession of marijuana. On the possession of marijuana, there'll be 6 months probation. There'll be substance abuse evaluation and follow any recommendations. That's contained within. So the main thing I want to make sure you understand is that this is a final adjudication of this case. Have you had all of your legal questions answered by your attorney?
Yes, sir, I
I
have.
believe this is in your best interest here today to enter into this plea agreement,
Yes, sir.
even though you're waiving the right to go to a trial and to contest all this.
Yes, sir.
Based upon that, the court will accept your plea. As stated, 6 months of probation as to the possession of marijuana, along with the other terms and conditions contained in there and the standard fees and costs. Thank you very much.
Thank you, Judge.
Do we have
Do you need him for anything?
is there a felony? Do we have a score sheet?
They're just misdemeanors, Judge, no
Misdemeanor.
score sheet
No score sheet.
needed.
Thank you, Your Honor.
Mr. Dees? Yes, sir. Thank you, Mr. Dees. Brian Allen, Ms. Dudley.
That's Brian Allen, 22 CF 1414.
Your Honor, in this particular case, the defense has at least 3 different times tried to set depositions. The victim's never been served. We've provided multiple different addresses whenever we could get them. There was contact with the victim in the beginning, but there has not been since the beginning. And at this point, after the 3rd time, trying to facilitate this process and not having contact with the victim, the state is announcing a null process at this time.
Very good. Very good.
Good to go.
Thank you very much. Destiny Jackson.
Your Honor, Destiny Jackson, 22 CF 2249. There is a waiver on file, Your Honor. We're asking for continuance. We did do depositions. Based on the depositions and the body camera, we have requested the transcript to file a motion.
State.
State has no objection, Your Honor.
Court will continue to the next pretrial on 12/27, 9 a.m. Larzaris Tellis.
Your Honor, it's Mr. Tellison, 22 CF 1117. This is the one we're still trying to work with mental health court to see if we can get him into that. We're asking for a continuance.
No objection.
We'll continue to 12/27.
Your Honor, that's all I have.
Very good. Thank you. Edgar Nunez, Mr. Flaherty. Morning, Mr. Swiatek.
Good morning. Morning, this is Mr. Nunez in case 2021 CF 1005. I've got a stipulated motion to substitute counsel signed by the client and also
Very good. Okay. You'll get me an order on that. Sign it.
Yes, sir.
Where are we at today, or with the substitution of counsel, where are we at?
I prefer to have a continuance on the matter.
Okay, I mean, we're deep into this. That's the only reason I'm asking. We're a year and a half into the case.
And, Your Honor, we had recently completed the depositions of the victim. We had an offer of 15 years DOC followed by 15 years of probation. These counts do carry up to 30 years in DOC. That offer would then expire today if he wishes to move forward.
So what do you have, where are we at as far as proceeding toward trial? Have you had enough time to evaluate the case?
Now, the case came in, I believe, late Friday night.
Okay. Ms. Balsam, what do you?
Your Honor, we understand, Mr. Schleicher.
I understand, I'm not pressing you for this cycle, I understand you just got the case. But the only question I have is whether we should announce, are you ready for last continuance? Are we ready to gear up next time, or what? That's what I'm,
Your Honor, I've talked to Mr. Flaherty. He's going to send over the discovery in the case. I'll have a better idea once I see that.
We don't object to this continuance, Your Honor, but the state stands ready to proceed after that. This has, as the court mentioned, been out there for quite a long time. Through no fault of prior counsel, there was some intricacies in getting the depositions taken care of, but those have now been done.
very good. We'll continue until the next cycle, 1227.
Thank you, Your Honor.
Try and, by that time, try and, kind of see where we're at. I'm sure you will, so.
And let me know if you have any difficulty.
Okay, thank you.
Thank you.
Thank you. Nicole Ramsey, Flowers.
Good morning, Your Honor.
Good morning.
Your Honor, in 2022 CF 1248, at this time, Ms. Ramsey would withdraw her previously entered plea.
I'm sorry, what's the case number?
If I'm not mistaken, 1248. Did I misspeak?
I've got 22 CF 960.
My apology. And I apologize, Your Honor.
Okay, I just want to make sure we're getting the
My
right one.
apology. To that 960, she would withdraw her previously entered plea, enter a plea of no contest. The sentence would be as follows: a withholding of adjudication of guilt. She would be sentenced to time served, $515 in court cost, $100 cost of prosecution. Your Honor, we would ask that she be given 90 days to pay those fines and costs. May I approach?
You may.
That's the offer, Judge.
Thank you. Thank you very much. So do we have a score sheet on this? Is this a not, is it felon?
I did not have one. I apologize.
That's all right.
I should.
Just get us a score sheet.
I have one, Judge. May I approach with it?
Sure. Show it to Mr. Flowers. Make sure he approves it.
That's good. Thank you.
Thank you.
Looks like my first time I presented.
Okay, Ms. Ramsey, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Just need to ask you a couple questions, make sure you understand your plea agreement. You heard your attorney state the terms of the plea agreement.
Yes,
Is
sir.
that your understanding of the plea agreement?
Yes.
I see that you signed the plea and sentencing agreement that your attorney just handed me. It's got your signature on it. Have you gone over this plea agreement with your attorney, made sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this plea, you're waiving the right to go to a trial, you're giving up some valuable rights. You've gone over that with your attorney, you're satisfied, this is in your best interest?
Yes.
Okay, very good. Do you have any other further questions?
No, sir.
Okay, based upon that testimony, the court will accept the plea. There'll be a withhold of adjudication, credit for time served, $515 court cost, $100 cost of prosecution. You'll have 90 days to pay, and then it'll go to collections. Would you add that on there just so we can make sure that it's detailed? Okay. Just the 90 days, yeah. Great, thank you very much. Okay, thank you, ma'am.
Thank you.
Thank you, Mr. Flowers. I think that's all you got.
Judge, that's all I have. Thank you, sir.
Thank you very much. Mr. Garlow, Ms. Gooden here? Yep. Good morning, Ms. Gooden.
Cheryl Gooden for Eldon Garlow, who is present. We are still ready for trial.
Very good. Very good. So we'll come back on jury review on November 10th.
Thank you, Your Honor.
You'll be give me some proposed jury instructions by then, that'd be helpful.
Thank
So we
you.
can just be going, we'll go over the details and the order. How long do you anticipate? Just,
One day.
okay.
Exclusive of jury selection, Your Honor.
So it'll be more than one day.
Just out of an abundance of caution, we never know how long it's going to take to pick the jury, so
Sure. Okay. I'm just trying to get an idea, because I think we've got a few
Quite
trials
a few.
coming up.
We
So,
do.
Okay. We'll see
ready.
you on this coming
10th, November
10th,
10th.
November 10th.
That's at 9 o'clock, Your Honor,
9
correct?
o'clock. And the defendant definitely needs to be there for that.
Correct,
This is
Your
an
Honor.
important hearing on your behalf, and you need to be involved with that. Okay? Thank you.
The next one.
Benjamin, go ahead.
I'm sorry. The next
Benjamin
one I have is
McNutt.
Benjamin McNutt, who is present, Your Honor, and approaching the lectern. We are still ready for trial.
Very good. And how long on this case?
same thing, I think. Your
One
Honor.
day.
Okay. Very good. So we'll come back on November 10th with some proposed jury instructions, et cetera, and make sure and be there on that. It's an important hearing for you as well. Okay?
Thank you, Your Honor.
Thank you.
The last thing I have, I'm covering for Mr. Adrian Middleton, if you'll allow,
Okay?
is Jason Rhodes, 21 CF 8.
Hold on a second. I got to find it in my,
I'm sorry.
that's all right. I just. Okay. Jason Rhodes.
Correct, Your Honor. It's my understanding that he, Mr. Middleton, and the state have worked out a plea. However, he is being held in Walton. So they're asking to pass it to December 1st to enter the plea, and Mr. Middleton is going to do a motion in order to transport.
Okay. Does that work?
Yes, Your Honor.
Okay. So we'll continue to December 1 at 9 a.m. and then transport for plea. Okay.
And that's all I have, Your Honor, if I may be excused.
Thank you, Ms. Gooden.
Thank you, Your Honor.
We'll see you on Thursday.
Yes, Your Honor.
Mr. Nope's here? Oh, he said he was going to be a little bit late. So let's skip over Mr. Nope's. Mr. LaPella. Elisa Kraft? Is that how, did I pronounce that right? Elisa? You may. Thank you.
I've handed the court a copy of the plea in absentia for this case on 22 CF 2195.
Very good. Would you announce the terms, Mr. LaPella?
I believe the terms, I don't have them with me. I gave it to the court.
You want to, here.
Your Honor, it would be a withhold of adjudication on count, let's see. Count 1 would be under 20 grams, so that would be a lesser included. Count 2 would be as charged, which is the driving while license suspended, which was a misdemeanor. It'd be a withhold of adjudication on both counts, 12 months of probation on count 1. That may terminate upon completion of the requirements, as long as there's no violations. That would be $270 in court costs plus $50 cost of prosecution. Complete a substance abuse evaluation and recommended treatment. Not to possess or consume any alcohol or controlled substances without a prescription. Random urinalysis, and obtain and show proof of a valid driver's license. That's on count 1. Count 2, the probation could only be for the 60 days.
Okay.
Or, I'm sorry, for 6 months. Could only be for the 6 months. So it'd have to be 6 months on that.
Mr. LaPella, is that an accurate rendition? I was trying to track it with, I think it appears to be, but I want to make sure you're confirmed that that's the plea agreement.
Yes, that's the agreement, Your Honor.
Okay. Ms. Kraft, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So speaking to that mic for me, so you can slide it right over. Okay. Ma'am, you heard the attorney, the state attorney, state the terms of the plea agreement, and that same plea agreement is contained in your plea and sentencing agreement. Do you understand that agreement? And
Yes.
are you in agreement with it? Are you in agreement with this plea?
Yes, sir.
And you understand that by entering this plea, you're waiving the right to go to a trial? This will be a final adjudication of your case. Do you understand that?
Yes, sir.
Now, this carries with it a number of other legal ramifications. Have you gone over all this with your attorney, what's on the plea and sentencing agreement, to make sure you have had all your legal questions answered?
Yes, sir.
Okay. You believe it's in your best interest to enter into this plea?
Sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be a withhold of adjudication on both counts. Count 1 will be a lesser included to a possession of marijuana less than 20 grams. And count 2 will be as withhold. As to count 2 as well, on the driving on a suspended, the misdemeanor, the withhold of adjudication on the driving on a suspended is 12 months probation.
Your Honor, it would have to
confusing,
be,
it's-
yeah, it would have to be 6 months probation on a driving while license suspended, since it's listed as
Right.
a second degree. It'd be 12 months probation on the lesser included possession charge.
Very good. So there'll be 12 months of probation, basically with court costs. Importantly, there'll be a substance abuse evaluation. That's a condition of this probation. You understand that? If you fail to complete that, could be a term for a violation. Do you understand that's an important part of this?
Yes, sir.
Okay. And also the fees and costs, no alcohol or controlled substance. Do you understand all that?
I do, yes, sir.
Okay, very good. And there will be, you'll have throughout the terms of the probation to pay all of the court costs, okay? And if you, you may have automatic early termination upon completion of all the requirements if there are no violations, okay?
Thank you.
Question, anything else, Mr. Wilson? Thank you very much.
We request the supervision fees be waived, Your Honor.
So ordered, thank you.
The obtain a driver's license, was that part of it?
Yes, Your Honor.
That she needs to obtain her driver's license?
That's true. Show proof of a valid driver's license as part of this.
And we request that be done during the 12 months also?
Absolutely.
Thank you, Your Honor.
Okay, thank you. Christopher Whitaker.
Sean Lupella for Christopher Whitaker, 20 CF 1935 and 20 CF 2312. Mr. Whitaker is present. Your Honor, we're scheduled for trial in this case. We're asking the court for the second week.
Okay.
And that would be on case number 20-1935, Your Honor.
So what we'll do is we'll come back on a jury review on November 10th. We're going to be looking at the whole lineup because we've got multiple cases. There will be some trials the second week. But we've got to see, how long do you anticipate for this case?
I think a day for our witnesses, Your Honor. Mr. LaPella?
I would, if, probably 2
Second
days
week
with
only
jury
has
selection.
3 days in it, so.
Yeah, that would be enough time if we had jury selection on the Monday and then another day, so 2 days with.
We should be able to do that.
Okay.
Would the court allow my client to appear by Zoom for the November 10th? He's traveling from out of town.
No, I think he has to be here. An important thing, you have to participate in that, and it's important that we have everybody here.
He was here last time and the state continued it, so that was,
Well,
understand.
hopefully,
Okay.
we're not going to continue it this time. Okay, thank you very much. Anything else on this case?
No, Your Honor.
Okay, thank you very much. Christopher Neese.
Good morning, Your Honor.
Morning, Mr. Madden.
Christopher Madden for Christopher Neese. We've reached an agreement. May I approach?
You may. Thank you.
Mr. Neese is going to withdraw his previous plea, enter a no contest plea to counts 1 and 3 to lesser included charges. The state in exchange is going to null pros counts 2, 4, and 5. The terms of count 1 is a adjudication withheld, 12 months of probation, standard fines, court costs, cost of prosecution, mental health evaluation and treatment, drug evaluation and treatment, random urinalysis, no contact with the victims, forfeiture of the firearm within 30 days. Count 3 is consecutive 12 months of probation, same terms and conditions, except that if he successfully completes 12 months of probation on count 1, he may apply for early termination.
And Judge, the count 1 is a lesser included offense of improper exhibition of a weapon. And count 3 is a lesser included offense of trespass to an occupied conveyance. The rest of the terms are correct, and the null process in the lesser included is based on the victim declining to prosecute.
Very good. Would counsel approach? Information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
Okay. You heard your attorney state the terms of the plea agreement. You've got 2 lesser included charges. One is the improper exhibition of a weapon, and the other is trespass of an occupied conveyance. Those are the 2 things. Is this a withhold or an adjudication?
They're withholds, Your Honor.
Okay.
On the misdemeanors.
There'll be a withhold of adjudication on these. Have you gone over the terms of the plea agreement? You heard your attorney state the terms.
Yes, sir.
Is that your understanding of what the plea agreement is? And are you in agreement with that?
Yes, sir.
Have you gone over all the plea and sentencing written agreement? I see you've signed back here, make sure. You have, looks like you've signed the plea and sentencing agreement. Have you gone over this, read it closely, gone over it with your attorney, made sure you had all your legal questions answered? Because there's a lot in this thing. Have you gone over it? Are you satisfied that you understand what's going on?
Yes, sir.
And importantly, you're waiving some valuable legal rights, right to go to a trial, the right to confront witnesses, right to contest this thing. This will be a final resolution of this matter. Do you understand that?
Yes, sir.
Okay, you believe it's in your best interest to enter into this plea?
I do.
Okay, very good. Based upon that, and the court is, counts 2, 4, and 5 are being null processed as a part of this plea?
That's right, Your Honor.
Okay. So as to count 1, in the lesser included improper exhibition of a weapon, there'll be a withhold. You got all these acronyms in here, counsel, that are, I'm having a hard time following. I want to make sure and get them right. So we've got a mental health evaluation. What's MOP?
Months of probation, sorry, Judge.
What is it?
12 months of probation.
Okay. So the core of this obviously is the 12 months consecutive to count one. So these are consecutive probations, not concurrent, right?
Yes, sir. We're
Okay. So that means that we're stacking these on top of one. It's just a total of 2 years of probation. Do you understand that?
Yes, sir.
There are also some important mental health evaluation, anger management, as well as substance abuse evaluations that are contained within this. You understand that's a part of these probation? And are we going to do the mental health first? Is that what's generally?
That's what Bridgeway.
Okay.
I think you're on.
That'd be better. And as importantly as with this, you've got no contact with the victims, Kelly Neese or Angela Griffith. Do you understand that?
Yes, sir.
That's very important. Even if they contact you, you got to stay away from them. Do you understand that?
Yes, sir.
And you've got to give up the firearm within 30 days. Very good. You will be eligible for early termination after completion of 12 months of probation if there are no violations and successful completion, okay? Are either of these felonies?
No, Your Honor.
Okay, so no score sheet. Very good, thank you.
Thank you. That's all I have. May I be excused?
You may.
Thank you, sir.
Your Honor,
Yes, sir.
couple of questions from probation. There's 2 victims. What about the kid? Is there a kid also? How, if he has no contact with the kid, how are we getting?
My father is the third party who will be.
We'll arrange that with DCF. Yeah.
All right, he had, hold on just a second.
Hold on. This is actually very, very important because I don't know that you fully appreciate that you're at risk if there's contact. And you got to be careful there's not inadvertent contact. And you actually are restricted from communicating, even through a third party in this case. So even with your child, you're not communicating?
And there's another issue.
I'm going to say right here, that's not the most workable situation. You're asking for a violation. You're asking for it. Mr. Barry is speaking from experience. That's why he's asking these questions. He's being nice about it, but he's.
And the only other suggestion I have, I could talk to the state, violent contact. You can amend the agreement and sentence from no contact to no violent contact.
I would be fine with that.
Okay. Why don't you put that note right on it, and that'll be good. Any other questions, Mr. Barry? That's a good point. We want you to be successful in this probate. I know it doesn't seem like it, but we really do, and that's why we're raising these. Sometimes through experience, probation has run into issues when there's no contact order, because everyone's, and like I said, everyone's like real amped up about no contact, because we're trying to protect people. That's one of the big reasons we're doing this.
As I've said in the past,
Chris, stop talking.
Don't say that. Just talk to your attorney.
Your Honor, we do request the supervision fees be waived.
Yes, sir.
And I have another more pressing issue. It says forfeit the weapon within 30 days. We're going to tell him he can't have one at all. So if he goes.
Where is the weapon? Why is it taking 30 days to?
He's forfeiting his rights to it from evidence, so the
Okay,
sheriff's
they
office
have
can,
it.
yes.
Okay, he doesn't have it.
He does not have, stop talking. I don't know. He doesn't have the firearm. We will make sure that he doesn't possess a firearm when it's turned over. Thank you.
Good questions. Thank you, Mr. Madden.
No, that's all I have. May I be excused?
Yes, sir.
Thank you.
Rebecca Thomas. Okay. Wesson Fuqua.
Judge, we've got an agreement we can approach.
Your Honor, Tim Gibbs on for Ms. Weston. I have her on 2 VOP cases for the record, 19 CF 2062, 19 CF 3185. Mr. Powell has managed to negotiate a deal with the state on Ms. Weston's behalf that covers all 4 of her cases. With that, I would move to withdraw as attorney of record on the violations of probation.
Okay.
Thank you, Your Honor.
The violations of probations are, get those numbers again?
Did you need those again, Your Honor?
Yes, sir.
19 CF 2062, 19 CF 3185.
First 2, Judge, on the agreement.
She's also.
Okay, I got you. They're on here. Okay, very good. And so the court will grant your motion to withdraw. We'll just put it on the record so you're not involved with it. Okay. Mr. Powell, would you announce the terms of the plea agreement, please?
Yes, sir, Judge. Thank you. She's charged with 2 counts, 3185A, possession of controlled substance, 2062, that's 219, grand theft auto. New charges are 2022, 2371C, larceny, grand theft, 750 less than 5,000, and 2372C, arson, 2nd degree. The violation of probation cases 219, 3185, and 219, 2062. Defendant will admit to the violations. The court will adjudicate her guilty. 20 months Department of Corrections. Both VOP cases to be served concurrent with the other charges, 2022 CF and 2372. $100 court cost for each case, $100 cost of prosecution for each case. Probation will be revoked and terminated. All monies owed will be reduced to judgment. In the case of 2022 CF and CF 2372, she enters a plea of no contest, is charged. That's on the arson. Your court will adjudicate her guilty. 21 months Department of Corrections concurrent with the other cases, violation of probation we just announced. And 415 court costs, $100 court of prosecution. There's $400 restitution to a gentleman named Christopher Beck, who was a victim in 2022-2371. All monies owed shall be reduced to a judgment. On 2022 CF 2371, the state of Nozzle Napros. That's on the larceny. She gets credit for all time served.
That's correct, Your Honor. That's the agreement.
Okay.
Kind of a long agreement, but we have a lot to work
It's
out.
all right. No, I appreciate you detailing it, sir.
And the null process is based on the victim declining to prosecute.
So, Ms. Wesson, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. So, you heard your attorney state the terms of the plea agreement. Do we have a score sheet?
I don't know if you gave me one. Yeah.
Yes. May I approach, Judge?
You may. You're good with the score sheet, Mr. Powell?
Yes, sir, I have, Judge. Thanks, Leo.
So, Ms. Wesson, you heard your attorney detail some details, kind of complicated, but the terms of your plea agreement. And that same plea agreement is contained in your written plea agreement that I see you've signed.
Yes, sir.
So my question that I want to make sure I understand, do you understand your plea agreement? And have you gone over it in detail with your attorney to make sure you understand all the legal ramifications of this? Obviously, some serious matters are being resolved here.
Yes, sir.
And it does include a Department of Corrections sentence. So you feel like you had all your questions answered and that this is in your best interest
Yes,
to
sir.
enter into this plea agreement?
Sir.
You understand that by entering into this, you will resolve all 4 of these cases, the 2 VOP cases as well as the 2 other cases. One of them is actually being dismissed. That's what null pros means.
Yes, sir.
Being dismissed by the state.
Yes, sir.
You understand that?
Yes, sir.
Okay. So based upon that testimony, the court will accept the plea agreement, and as 2371 is going to be dismissed, 22 CF 2372, there'll be a no contest, there'll be an adjudication of guilt, 21 months, Department of Corrections, concurrent with the 2 VOPs. There will be credit for all time served. There's a number of court costs that are contained in here. The restitution to Christopher Beck of $400, that'll be paid first. All monies will be reduced to judgment. How do we do that where it's reduced to judgment if Beck is paid first?
Beck's the main one that's got to be paid, Judge, and the rest of it reduced to judgment.
Now, how does that?
It just all goes together.
Okay. Okay,
Mr. Beck will probably be paid within the next 2 weeks.
okay, very good. So, and the violations of probation will all be done concurrent. That'll also be 21 months in the Department of Corrections. So they'll be served at the same time, not on top of one another. Any questions with any of these? Okay, thank you, ma'am.
See you, Candy. Thank you, Judge. That's all I have.
Thank you, Mr. Powell. Artsaw, Mr. Shaw.
Morning, Judge.
Morning, Mr. Shaw.
Tim Shaw for Jesse Alexander Hartzog, 20 CF 2976. Judge, Mr. Basso and I have discussed this case. We'd like to put it on for Thursday in hopes of a resolution.
Very good. So we'll come back November 10th, 9 a.m.
Thank you, Judge.
Thank you, Mr. Shaw. Rivera, Sixto Rivera.
Judge, Mr. Rivera, as I understand, just stepped out, went to the restroom. We are asking the court to continue this case anyway. I think Ms. Basso doesn't have any objection.
There's no objection, Your Honor, and I did also see Mr. Rivera here earlier.
Okay. So we'll continue to 12/27, 9 a.m.
Thank you, Judge.
Thank
And
you, Mr.
lastly, if I may take
Sure.
Derek McKinney. He's probably listed under Jack Wilkins, my co-counsel on the case. Derek McKinney.
Hold on a second. Let me find this. Sorry.
If it's listed, if you're under attorney's last name, it'd be under Wilkins, Your Honor.
Yep, got it.
Judge, in Mr. McKinney's case, we have been in contact and speaking with Ms. Glisson a good bit. We would also like to put this on Thursday. There was a issue that had come up that we need to further address with our client and give him a couple days to digest it. However, we anticipate it being resolved on Thursday.
Very good. Come back on November 10th, 9 a.m.
Yes, Your Honor.
Thank you very much.
Thank you, Judge.
Thank you, Your Honor.
That's all I have.
Okay. Thank you, sir. Mr. Tony. Charles Detz.
Your Honor, we have an agreement on this. However, he is having a little trouble. We're going to need about 20 minutes, so we can pass this for about 20 minutes. We should be able to take care of that.
Very good. You want to do Jeremy Dixon?
Mr. Dixon, we've asked for a continuance on that one, Your Honor.
Is he here?
No, he has a waiver file. We've, in this particular case, we have depositions get set. I think they're set in the early part of December, and we also have a motion to suppress pending.
Okay. Very good. State?
No objection, Your Honor.
Okay. We'll continue until 12/27, the next trial cycle.
And then the next one is 21 CF 108, State versus Brian David Pate. We're asking for a continuance of that one as well, Your Honor. We're trying to set the deposition of one of the key material witness in this particular case, who has recently just been incarcerated, so we're having little issues on that.
Yes, I understand. State okay?
Yes, Your Honor.
Obviously. Okay, we'll continue until 12:27. Where is he? Is he in state DOC?
Yes, I don't know. I don't know. He was in the county.
Oh, he was in the county?
I believe Mr. Russell represents him.
Represents him.
Yeah.
So we have to get his permission to take the deposition, and in understanding there may be some incriminating issues that he may have. He's objected until that matter is settled. And it's my understanding that it should be settled pretty soon, Your Honor.
Okay, very good. Okay, so just wave at me when your client gets here, and we'll bring you back up.
Thanks, Judge.
Okay, thank you. Robert McDonald.
Can I just give it to you?
Good morning, Your Honor.
Morning, Mr. McDonald.
How you
State,
doing?
would you announce the cases?
Yes, Your Honor. His cases are 19 CF 3440, 19 CF 3443, 19 CF 3447, 20 CF 1360, 20 CF 1367.
Okay, Mr. McDonald, you're still preferring to represent yourself?
Yes, sir.
Okay. Your answers to my prior questions about your understanding about the process and whatnot,
Yes,
still
sir,
the
I will.
same? Your situation hasn't changed?
Not at the moment, sir, but I'm trying.
Okay. Where are we at here on this case?
Well, Your Honor, he said he was ready for trial. So the state is ready for trial on 19 CF 3.
Which one are you trying to do?
447.
I'm sorry?
19 CF 3447, the attempted burglary of the unoccupied structure, possession of burglary tools, and criminal mischief.
Okay. Mr. McDonald?
Yes,
Ready
sir.
to go on that case?
Yes, sir.
Okay. Okay, so we'll come back on November 10th,
Yes, sir.
9 a.m. for
Sure.
jury review. We'll see where we're going.
Yes, sir.
How long is that going to take, a day?
Yes, Your Honor, and at that time, is the court going to continue the other cases to the next
Yes.
cycle?
Or we can do it now. I mean,
Just go ahead and just say
we're
this.
continuing the other cases, 20 CF 1350, 20 CF 1357, 19 CF 3440, 19 CF 3443. So all those, just focus on the one case, okay?
3447, sir.
That
one's
is
set for
correct. The
trial.
one that they've announced ready is 19 CF 3447.
Your Honor, Ms. Rivers, before Bert was discharged, did you have a deal for me? I remember briefly that you said something about 36 months at one time.
That's correct.
I would like to just negotiate with you on that time, and instead of going to trial, and if the judge will allow me to negotiate with you on the 10th.
That's fine, but I won't go below 36.
Okay, that's fine, but I do have
You
26
can
months.
negotiate with her now if you want. You want to talk to her?
Yes.
She's pretty well telling you what her position is.
Yeah, she showed me
I don't
that.
want to get in the middle of your negotiation, but.
We could always meet.
Yeah, I can
Okay.
make it right there.
You want to meet with her a little bit?
Yes, sir.
Okay.
When
When we take a break,
Okay.
we'll hold the defendant, and you can come and talk to her. Okay. Brian Crocker, Ms. Flowers.
Morning, Your Honor. This is Brian William Crocker. Here this morning, Jennifer Flowers on his behalf for the record on 22 CF 978. We have reached an agreement with the state. Mr. Crocker is going to be withdrawing his previously entered plea of not guilty and enter a plea of no contest as charged to count 2 only, possession of drug paraphernalia. The state will be dismissing count 1, grand theft auto.
That's correct, Your Honor. We've never had any contact with the victim. We've tried multiple times, sent multiple letters, phone calls, no contact. So at this time, we are announcing a null pros count 1, grand theft auto.
Very good.
And as to count 2, the agreement is to plea as charged to the misdemeanor possession of drug paraphernalia, adjudicate guilty, 11 months, 29 days, probation, $275 in court cost, a $100 cost of prosecution, and a $150 cost of defense. And those, we would request 180 days, or he's on probation, I'm sorry.
Okay.
Those will be paid during the time
Sure.
of probation. Let me have the state sign.
Sure.
May I approach? Your
You may. Thank you. And Mr. Crocker, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of your plea agreement that I see is contained in the written plea and sentencing agreement that you've signed.
Yes.
Is that your understanding of what the plea agreement is, and are you in agreement?
Yes, Your Honor.
Okay. So the 1 count, the grand theft, will be dismissed. That's what null pros means. As to the possession of paraphernalia, you'll plea as charged, adjudication of guilt. You'll have 1129, just 1 day short of 12 months probation, and you've got 275 court costs, et cetera. All those need to be paid, are required to be paid during probation. That's part of the terms of your probation. Do you understand that?
Yes, sir.
Okay. You understand that by entering into this plea, you're waiving some valuable legal rights. The main thing is to be able to contest this. You're waiving that right. This will be a final adjudication of this matter. It'll be completely resolved, obviously.
Yes.
Except for the probation you got to continue on. Do you understand all that?
Yes, Your Honor.
You believe it's in your best interest to do this?
Yes.
And you feel like you've gotten all your legal questions answered?
Yes, sir.
You satisfied with your legal representation?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea. Count 1 will be null pros as per the state's announcement. And count 2, possession of paraphernalia, 1129 probation, court costs, et cetera, per the plea agreement.
Yes.
In Your Honor, he does have another case. I see that the attorney is not in the courtroom right now, so if you would just hang out until the attorney comes back in.
What's the
Address
other?
your other case. Your Honor, he has 22 CF 1950.
Who's the other attorney?
Miss Etheridge.
Miss Etheridge, okay.
We request the supervision fees to be waived then.
So ordered. Thank you.
You're good.
We'll try and, you want to go over and talk to him now, or? Yeah.
We just don't hang tight.
Yeah. As soon as Miss Etheridge comes in, we'll take it.
Okay, yeah.
Matthew Hartley, you want to do that one?
Sure.
Go ahead.
This is Mr. Matthew Hartley, Your Honor, in 22 CF 1141. We're here today, and I appreciate the court allowing us to address his bond briefly today in 22 CF 1141. He was issued a capias for failure to appear to a pretrial conference on June 27th, 2022. I provided information to the state that I got from Covington County Jail showing that he was in fact in custody there. He was arrested on the 22nd of June and then was brought here. He was never released. He was brought here. So I'm just asking, and I don't believe there's an objection from the state, to reinstate the bond on his case.
State has no objection.
Court will reinstate the bond and withdraw the failure to appear.
Okay, thank you, Your Honor.
Thank you, Your Honor.
And we can, I think he might already be set for the 27, or the 28th.
What's the next hearing on, is this just regular?
Once you get out.
On November 10th, there's a plea day on November 10th. We'll try and run, is that on a different case or the? Okay.
Oh, has he not entered a?
Let's put him on the pretrial, 12/27.
Wonderful, okay. So you've got court on the 27th? Yeah, you're good. Yeah.
Now, I've got on my list of inmates Ryan Bielik, Ms. Flowers, but I don't have him on my list. Is he today? Is Bielik here?
I believe he's Miss Casey Etheridge's case, Your Honor.
Oh, is it? That's what it
Is
is.
that correct, ma'am?
He's not any longer. We had to withdraw due to a conflict.
I
I
just
think
don't
I
have him
just-
at all on my,
You got it. You just got it.
He might still be.
are you? you
No,
know
he's
what-
on the list. I've never met him. I was apparently just appointed. I've never met him, so
Why
I
don't we
would
just-
be.
We'll bring him
Yeah,
out. You can
okay.
introduce yourself. We'll continue
Yeah.
it, and we'll go from there.
Okay, thank you.
Do you know what the charge, does the state have a type of the
Your
charges?
Honor, I think he has multiple cases. The case I have him on is 22 CF 2278.
Oh, I don't have that one.
And Your Honor, we also have him on 221477 and a VOP on 210403.
Okay. So, Mr. Bailey, you've got several cases, obviously, you're aware of that.
Yes, sir.
The public defender has withdrawn, and you've been appointed the Office of Regional Conflict Counsel, which Ms. Flowers will be your attorney. So we just wanted to kind of bring you out. We're going to go ahead and continue all of these cases to 12/27. That's the next pretrial. But in the meantime, she'll be talking to you, kind of trying to figure out kind of where you're going with everything, okay?
Yes, sir.
Question?
No, sir.
Okay, thank you very much. 12/28, thank you. 12/28. Brandon Severns. Ms. Etheridge, after we do this, you want to do Crocker, because he already got one of them, we'll deal with it.
Okay, wonderful.
Your Honor, this is Mr. Brandon Severance, present in 22 CF 2135. Tim Gibbs on behalf in that case.
And I'm Jennifer Flowers on behalf of Mr. Severns in 21 CF 1879.
Your Honor, I'm requesting to move this to December 1st. We're still waiting on response from Phoenix House for treatment for Mr. Severance. So hopefully we can get that soon and get that by that date to get him on his way.
Objection. I would ask to do the same thing with our case.
We'll continue to December 1st.
Yes, Your Honor.
Okay, and
See you later.
Thank you. Very good, thank you. And let's do Crocker and
I
Ms.
can have one moment, Your Honor. It's gonna-
You need to talk to him?
Yes, I do.
Okay, so let's just continue with Ms. Flowers. Angela Taylor?
Ms. Taylor is here, Your Honor, and Jennifer Flowers on behalf of Angela Renee Taylor in 4622 CF 1564. We have reached an agreement with the state, and Ms. Taylor is prepared to withdraw her previously entered plea of not guilty and enter a plea of no contest as charged. The terms of the plea would be an adjudication of guilt, 12 months standard probation, followed by 24 months of community control. She's to have no contact with the victim. She'll have a 1-year driver's license suspension, subject to random urinalysis, and no possession of drugs without a prescription, and no alcohol. While on probation, this being the important part here, is while on probation for the first year, she is to enter and complete 1-year residential treatment at Saving Grace program, followed by a 6-month internship at Saving Grace. She is currently enrolled already, and so she's actually here with a representative today and will
How
return
long
to
have
the
you
program.
been enrolled?
Almost a month.
It's a very good program, as you
And,
probably know by now.
And once Saving Grace is completed, she is to follow up with a mental health evaluation and treatment, any recommended treatment, and a substance abuse evaluation and any recommended treatment, and take any medications as prescribed. There'll be $667 in court costs, a $100 cost of prosecution, a $150 cost of defense, and we would ask to waive cost of supervision. Let me make sure everybody's signed. Okay.
State in agreement?
State is in agreement, Your Honor. Do you have the score sheet?
No, thank you. Ms. Taylor, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So, this is, you heard your attorney state the terms of the plea agreement. I see that that same plea agreement is contained some detail in the plea and sentencing agreement. Have you gone over this in detail with your attorney, made sure and ask all your questions, and are you in agreement with this? You believe it's in your best interest to enter into this plea agreement? And you understand that by entering into this plea agreement, you're waiving the right to go to a trial and to contest all this. You understand that? That's an important thing. And this will be a final adjudication of your case here today. Okay? So, so based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt. Do we have a name for the victim? I think we need to put that in the plea and sentencing agreement.
Nicole Gray.
Nicole Gray.
I'll ask you just to stick that in here in just a second.
Yes, sir.
And there'll be 12 months of probation followed by 24 months of community control. The probation, obviously, importantly, you'll be on your residential treatment at Saving Grace, followed by 6 months internship at Saving Grace as well. So there's a number of other things. Importantly, when you get through with this, you know, the mental health component is an important thing. When you look at addiction, I've come to understand there's almost a total link on that. And so you need to address that and work through that as well. There will be a waiver of cost of supervision. The other fees and costs will be during the terms of the probation. Very good. Anything else other than that, counsel? Mr. Berry?
Your Honor, I know that the Saving Grace program, they travel, and sometimes they travel outside of the state of Florida.
Yes, sir.
While she's on probation, certainly she will be able to do that.
Right.
Once she gets on community control, that's going to be different, but that's on down the line. I would request that while she's on probation, the court allow her to travel for purposes of Saving Grace.
You want to put that probably needs to be in the plea agreement.
It would just prevent us, maybe her officer, from saying she can't do it.
Sure. State okay with that?
Thank you, Your Honor.
Thank you. It's good nuance. Where's Saving Grace located?
Baker, Florida.
Baker. Thank you. Okay. Good luck, ma'am. Willie Williams?
Yes, Your Honor. Mr. Willie James Applin Williams is present and approaching. He is here today to address 22 CF 1866, Jennifer Flowers, for the record on his behalf. He's prepared to enter a plea of no contest as follows. He'll plead to the lesser included offense on count 1. The agreement would be that he would plead to a lesser included offense of resisting an officer without violence, a misdemeanor, for an adjudication of guilt and credit for time served. That's pleading down from what was a third-degree felony, fleeing or attempting to elude. On count 2, he'll plead no contest as charged to possession of controlled substance, adjudicate guilty, give him credit for time served, $515 court costs, a $100 cost of prosecution, a $150 cost of defense, and that money would be due to be paid within 180 days before being sent to collections. Let me get the date. And the defense stipulates to the score sheet as well. Your Honor, may I approach?
You may. Thank you. Mr. Williams, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So, you heard the terms of the plea agreement that your attorney just set forth, and I'm looking at the plea and sentencing agreement that has your signature on the end of it. That contains the same plea agreement? Have you gone over this with your attorney, made sure you had all your legal questions answered about this plea agreement? Because you're waiving some valuable legal rights. Just want to make sure you're doing it freely and voluntarily. You're waiving the right to go to a trial and contest all this. This will be a final adjudication of this case. Do you understand that? Okay. Very good. Based upon that testimony, the court will accept the plea agreement. As to count 1, there'll be a lesser included of resisting an officer without violence, adjudication of guilt, credit for time served. Count 2, possession of a controlled substance, adjudication of guilt, credit for time served. Standard court costs that are contained in the plea agreement, all of which will have to be paid within 180 days or it'll go to collections. Okay, questions? Okay, thank you very much. Sir.
And I believe that's all I have today, Your Honor, if I may be
Okay,
excused.
thank you very much. Okay. You ready? You want to do Crocker, Ms. Etheridge, or you want
Yes,
to
Your
do
Honor, that's
Belcar? You ready to do Crocker?
Yep.
Okay, Crocker.
Casey Etheridge for Mr. Crocker. If I might have 1 moment so you can sign, Your Honor. Would you like to accept? Okay, Mr. Crocker would like to enter a plea of no contest and accept the state's offer we're here in 2022 CF 1950, Mr. Brian Crocker. And for count 1, a lesser included offense of resisting an officer without violence. For adjudication of guilt, 11 months, 29 days of probation, cost supervision waived, $275 in court costs, $50 cost of prosecution, $100 in public defender fees, 20 hours of community service work. And on count 2, adjudication of guilt, credit for time served. Count 3, adjudication of guilt, 11 months, 29 days of probation concurrent with count 1. And this would be concurrent with case number 2022 CF 978.
Very good.
That's correct, Your Honor.
Thank you.
May I approach, Your Honor?
Thank you.
And it is to misdemeanor, so there won't be a score sheet, Your Honor.
Very good. Crocker, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes.
You heard the terms of the plea agreement that your attorney just laid out, and I see that it's contained also in the the written plea and sentencing agreement that you have signed. Have you gone over this agreement with your attorney?
Yes.
Made sure you had all your legal questions answered?
Yes.
You understand you're waiving some valuable legal rights, right to go to a trial, right to contest witnesses, et cetera.
Yes.
This will be a final adjudication of all your cases, as stated in the plea agreement. Do you understand?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement?
Yes, I do.
Okay. And you satisfied with the legal representation?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea. As to count one, there will be a lesser included charge of resisting an officer without violence, to which there'll be an adjudication of guilt, 11 months, 29 days of probation, cost of supervision waived, standard court costs and fees, 20 hours of community service. Count two, attaching an improper tag, adjudication of guilt, credit for time served, and adjudication of guilt as to count three, resisting arrest of an officer without violence, 11 months, 29 days of probation. That'll be concurrent with the other ones. They'll be served at the same time. And so, very good. Anything else? Thank you.
Thank you.
Bell Carr. Azalin Bell Carr.
Casey Etheridge for Ms. Belcar. We're here in 2021 CF 1354. If I may have one moment, Your Honor. Ms. Belcar would like to enter a no contest plea and accept the state's offer, and it would be adjudication withheld, 24 months of probation, cost of supervision waived, $415 in court costs, $100 cost of prosecution, $150 in public defender fees, 50 hours of community service work, may early terminate probation after 12 months if all terms are complete and there are no violations. May I approach, Your Honor?
You may. Thank you. Ms. Belcar, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Ms. Etheridge, you're okay with the score sheet?
Yes, Your Honor, no objection.
You heard your attorney state the terms of your plea agreement, and I see that the same plea agreement is contained in your written plea agreement that you've signed.
Yes.
Have you gone over this plea agreement that's written in detail with your attorney? Make sure you had all your legal questions answered?
Yes.
You understand that by entering into this plea, this will be a final adjudication. You're waiving the right to go to a trial. We're just wrap this thing up. Do you understand that?
Yes.
It'll limit your ability to appeal it and take other action. You believe it's in your best interest to enter into this plea? Okay. And you're doing this freely and voluntarily?
Yes.
Very good. Based upon that, the court will accept your plea agreement. The court will have an adjudication withheld, 24 months of probation. Cost of supervision will be waived. Standard court costs and fees that are contained in the plea agreement. 50 hours of community service. You may terminate early after 12 months if all your terms are complete and there are no violations. Okay? Very good. Thank you very much. Malik Bradshaw. So Mr. Tony, are you ready? You still negotiating, Mr. Tony? Are you ready?
I'm being corrected, Your Honor. Need a few more minutes.
Okay, well, take your time. That may take some time to complete that task.
Casey Etheridge for Mr. Bradshaw. We're here in 2022 CF 1580. And Mr. Bradshaw would like to enter a no contest plea, and he's entering a plea to count one, a lesser included offense of resisting officer without violence for adjudication withheld, 1 year of probation, cost supervision waived, $270 in court costs, $50 cost of prosecution, $50 in public defender fees. And he must obtain a valid driver's license or clear to the extent possible, which he actually does have today, Your Honor, so for the court's knowledge from what he's telling me, so. And then count two, adjudication withheld credit for time served.
Thank you. Okay, Mr. Bradshaw, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of the plea agreement that your attorney just stated, and I see that it's in the written plea and sentencing agreement that you've signed.
Yes, sir.
Have you gone over this plea agreement with your attorney? Are you in agreement with it?
Yes, sir.
And you believe it's in your best interest to enter into this plea agreement?
Yes, sir.
You understand that by entering this, you're waiving the right to go to a trial, this will be a final adjudication of this matter?
Sir.
Limits your ability to appeal it, et cetera? Okay. You are satisfied with your representation of Ms. Etheridge? Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be a lesser included charge in count one of resisting an officer without violence. Adjudication will be withheld, 1 year of probation, cost of supervision waived, standard court costs and fees. You must obtain a valid driver's license or make, efforts to do so during the term of your probation. As to count two, driving on a suspended license revoked, you get credit for time served. Okay, any questions?
And can I get early termination for the probation, or?
I think that you always have a right to have early termination at the halfway mark.
The state would have no objection with him terminating in 6 months.
Okay, awesome. Thank you.
Yeah. Isn't that automatic? Isn't that a part of the statute? We don't have to put it in the plea agreement?
Y'all just usually say it.
No, I understand, but I'm just wondering. This is a technical question, not for this one.
I believe that the standard plea agreements, though, say something different than what the statute. So therefore, this would be in his best
A little
interest
more
protection.
It's a little more lenient the way it's offered in a plea agreement.
No,
No? About the same?
no, it's actually,
The opposite? Oh, okay. Okay, so 6 months. If you got everything square, you can seek early termination, okay?
Very much.
Thank you.
Your Honor, can we briefly call back Miss Belle Carr?
Sure. Is she still here?
Yeah, she's right here.
Okay, there she is.
She resides in Miami, which is no problem for us for transfer purposes. However, she just advised us that she's traveling outside the country in December. They'll let her go. It's getting back.
Yeah.
So
Unless you order it.
if we order it, if you're allowing her to go on here, you tell them where you want to go.
My family is from St. Kitts. It's an island in the Caribbean. We usually go every year for Christmas, and I was just hoping to go for 2 to 3 weeks. It shouldn't be more than 3 weeks. I'm due to come back on January 7th.
State has no objection, Your Honor. This is a very first offense, so. But you're going to have to give a specific amount of time
No,
to.
of course.
We can do a travel permit for her. If she was staying here, we could handle it locally, if you will, but she's transferring to Miami, and I don't want her to get down there, think she's going to go on a trip, maybe leave on a trip, and not be able to get back.
I mean, the court will approve it.
Okay,
So
thank
just,
you. That's all
need to
we
make
need.
sure and pay attention to the probation officer to make sure and follow exactly what needs to be done, because we don't have control of immigration. They do strange things. Sometimes they're real hard on things. Sometimes they go away. They don't even show up. So we're not always real clear what's going on. Okay?
That will assist us from our perspective, though.
Okay, thank you. Joshua Brewer.
Casey Etheridge for Joshua Brewer, if I may have one moment. Here, just sign here. And Your Honor, Mr. Brewer would like to accept the state's offer of PTI, and I believe that Christine, are you showing it for the plea or no? Could it just be? Yes. One moment, Turner. And Your Honor, this is a PTI referral with a plea, so.
Very good. Sure, just. Very good. I think this goes to the probation.
Yes, it does. I was just making sure.
No, I appreciate it. Okay. So you understand how this works, pretrial intervention. If you are successful in all this, then it goes away, but if not, it comes back before the court, and you got to deal with it, so. Just do what you need to do, you know what you need to do, just do it right, follow through, show up when you're supposed to, and it'll get done.
Your Honor?
Okay. Yes, sir.
We're asking if this PTI be done with a plea.
Yeah,
Okay.
that's why I
Contest is
was
acceptable.
asking.
We need to have it a written plea, that's why I didn't do the colloquy. Should it be a written plea agreement if we're doing a plea?
Yes.
Okay. We're gonna
I mean,
have to-
sometimes you can do, I understand the way I've done it, sometimes the PTIs are not with the plea, sometimes they are, right?
And we prefer this to be with a plea, Your Honor.
That's fine.
And with the agreement, it'll protect Mr. Brewer as well.
Okay. So we're gonna take a short break here, and then maybe you can do it during the break.
Thank you, Your Honor.
Dillabaugh? Want to do that, and then we'll take a short break.
Sure.
So when we come back on break, Mr. Nopes, you need a little more time, or?
I need a little more time. I gotta run back to my office. I just realized I didn't put the tie on. And I gotta tweak a plea agreement real quick. I'll be back.
Okay. We'll be here most of the day, unfortunately. Mr. Tony, did you guys get everything squared away? And Ms. Rivers, are you working with Mr. Tony? Is that your case?
No, it wasn't mine.
Whose was it? Was it your case?
It's Ms. Glisson.
Mr. Tony?
Yes, Your Honor, I think he had more than one, but I have him on.
Well, he's only got one left. I
Debts.
think.
Okay, then it's debts.
that-
DETZ. He's just correcting the plea agreement.
Okay, okay.
So he should be back
Well,
shortly.
well, whenever he gets back, that's fine.
All right, Casey Etheridge for Mr. Bullivo. We're here in 2021 CF 2621 and 2021 CF 2633. Mr. Bullivo would like to enter a no contest plea and accept the state's offer. And so in 2021 CF 2621, it would be count one, adjudication of guilt, 6 months of community control, followed by 18 months of probation, cost supervision waived. I didn't have the, State, what's the court cost on this? I apologize, I didn't put it in there. Do you know?
Changing, I think it's 6:15.
615, okay.
I would defer to Madam Clerk on
Okay, I'm not sure of the court costs. I put 615, $100 cost of prosecution, $150 in public defender fees, a GPS monitor at the rate of $1 a day. Count two, adjudication of guilt, 6 months of community control, followed by 18 months of probation, concurrent with count one. And then in 2021 CF 2633, count one is adjudication of guilt, 6 months of community control, followed by 18 months of probation, concurrent with 2021 CF 2621, $615 in court costs, $100 cost of prosecution, $150 in public defender fees, and there's a suspended sentence of 80.625 months, concurrent on both cases.
That is the state's agreement, Your Honor. I do have the score sheet from Ms. Etheridge for review. And if you don't mind
While
providing
you're
it to the
here.
judge.
Yeah, sure. Because he has to sign too still.
Whoops.
Oh, you're fine.
Nope, one more.
One more. And Your Honor, it'll just take me a moment because I have to have him sign it.
Your Honor, this is Ms. Berkman's case, but we did review it.
Yes, because it would break his heart. May I approach?
May. Okay, Mr. Bilbao, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. You heard your attorney state the terms of the plea agreement? Yes?
Yes, sir.
And you have signed the written plea agreement that contains the same plea agreement. Have you gone over this in detail with your attorney? I know this has been going on for a while. Had an opportunity to make sure and get all your legal questions answered about this plea agreement?
Yes, sir.
And obviously, I'm going to go over it. It's a detailed plea agreement, but one of the terms of this is a suspended sentence of a little over 80 months on both cases that'll run concurrent. You understand that? So that means that if there's a violation of this, you have more consequences. Do you understand that?
Yes, sir, I do.
So you've had all your legal questions answered? Are you satisfied that this is in your best interest to enter into this plea agreement? Why? Why is it in your best interest to enter into this plea agreement? I'm sorry?
resolve this matter, get me home, get me to continue, just to get my life started back over, move forward. That's my number one goal.
Okay. Very good. And you have had all your legal questions answered, you're comfortable with this, that this is in your best interest? Okay. Very good. Based upon that testimony, the court will, in case number 21 CF 2621, will be an adjudication of guilt, 6 months of community control followed by 18 months of probation, some standard fees and costs, GPS monitor of $1 a day. So there'll be GPS throughout the probation, is that correct? Okay. And as to count 2, adjudication of guilt, 6 months of community control, followed by 18 months probation, concurrent with count 1. Then the other case, 21 CF 2633, count 1, adjudication of guilt, 6 months of community control, followed by 18 months probation, concurrent with 21 CF 2621, standard court costs in these as well. And on both cases, suspended sentence of 80.625 months on each of these cases that will run concurrent. Very good. Any questions, Mr. Billabong? Any questions? Okay. Thank you very much.
Your Honor, GPS to be attached prior to release.
That is correct. Thank you. Score sheet? Okay. With the minimum being the 80.60, is this a downward departure technically because this is suspended?
Yes, Your Honor, it is technically a downward departure. We do agree that there is a legal basis, therefore, this is an agreed upon plea agreement.
Thank you. Very good. Thank you. Mr. Tony, are you ready to go?
Yes, sir, Your Honor.
Okay. Hold on, let me pull your case. Let me get your case again.
Delt's approach. My approach, Your Honor?
Yes, you may. Sorry. Thank you. Okay, great.
Are we ready, Judge?
Yes, sir, please.
Your Honor, pursuant to negotiations with the state, the defendant withdraws his previously entered plea of not guilty and agrees and stipulates to the below offense. The defendant pleads to the lesser charge of felony battery and sentenced to 3 years probation, DET, RUAs, no possession of drug and alcohol, 100 hours of community service, anger management.
What's DEAT?
Drug evaluation and treatment.
Sorry. Sorry.
I'll write it out next time.
That's all right.
Anger management assessment and batterers intervention if appropriate, and no contact with the victim. The restitution to the victim in this case will be $2,300 and $2,355. And he's also responsible for court costs and the cost of prosecution. Your Honor, in this particular case, there are 4 defendants, and they are all joint and severally liable for the amount of $2,355. And I scribbled that on the end of the agreement. But for the record, that's what the number amount to, and there are 3 other defendants, co-defendants in this particular case.
And who is the victim? I think we need to spell that out.
The victim is Bill Matlock.
I'm going to ask you in
Senior.
just a second to insert that in here so we're clear about that. The one thing I want to get clarification. I think I know what you're doing, but make sure we clarify it. The assessment and batter's intervention needs to be, there's an assessment at Bridgeway where you can either do anger management or BIP, depending on different things in domestic violence. It's called some assessment. That's what should be done, because in certain cases, anger management isn't applicable. Other times, better, it has to do whether it's intimate partner violence or if it's somebody in the family or if it's I mean, it's not in the family. Those are different types of things. We want to try and get something that will be of assistance so you don't come back into court with these kind of charges, because the next time you come back in, you know, these things stack pretty heavy on one another, and best that you get this figured out, because if you come back, you may have a hard time getting a non-incarcerative deal. So, anyway. So, I don't know how to, I mean, the way you've got it, it may say anger and if appropriate. So you have to do, so what you're basically doing is doing the assessment and then them.
Then if necessary, then he'll proceed to.
I think you've got the right intent. I just want to make sure. Unfortunately, they've changed over the years at Bridgeway about how they handle these, and I think they've got an assessment now that handles either or. Okay. So with that caveat, Mr., is it Detz? Is that?
Yes, Your Honor.
Mr. Detz, you heard your attorney's rendition of the plea agreement. Is that your understanding of the plea agreement?
Yes, Your Honor.
And I see you've signed the written plea agreement. Have you had all your legal questions answered from your attorney?
At this point, yes, Your Honor.
And you've gone over all the different elements and had all your legal questions answered? Because
yes, Your Honor.
There's quite a lot that goes into these plea agreements, not only what's in the plea and sentencing agreement, but the waiver of certain rights that are very valuable. Right to go to a trial is the biggest one. You believe it's in your best interest to waive all those rights? And
Yes,
have
Your
a
Honor.
final adjudication by this plea agreement?
Yes, Your Honor.
And you believe you've gotten good legal representation on this?
Yes, Your Honor.
Very good. And did you say that you're okay with the score sheet?
Yes, Your Honor.
Okay. So the court will, based upon this testimony, the court will accept your plea and sentencing agreement and withdraw the not guilty plea, and you're going to plead to a lesser charge of felony battery, and you'll be sentenced to 3 years probation. You know, you need to do the drug evaluation and follow any testimony. It's important that you jump on that, because sometimes it takes some time to do that. Don't wait 6 months. That's an important thing. 100 hours of community service, then do an evaluation and figure out what's appropriate as far as batter's intervention or anger management. No contact with the victim, restitution, joint and severable, in the amount of $23.55. I'm going to ask you to put the name of the victim in, Mr. Tony, just so we can be clear. Be careful with that victim. Everyone takes those things real serious. Even if the victim contacts you, you're in violation. They're not. Okay, so don't get caught up in that. You receive a phone call, just don't accept it. If you run into them in public, just walk away. It's not, you know, nobody's going to trick you. You're not going to get caught up in it. It's not like that, but sometimes people don't understand how serious the no contacts are.
Understood, Your Honor.
Thank you very much. Okay, anything else, Mr. Tony? Thank you.
No, sir, Your Honor.
Okay, very good. Thank you very much.
That's all I have, Judge. May I be excused?
You may.
Good seeing you, Judge.
We're requesting the supervision fees be waived.
Yes, sir. Yes. Supervision waived.
Hey, wait, sir.
You still have more to go.
Okay. Let's go ahead and take our morning break.
Oh, yeah.
And we'll go from there. Have you're going to get a chance during the break to talk to Mr. McDonald?
Yes, Your Honor.
You are. Sorry, not you. Sorry. I'm looking at the wrong person. Ms. Esser is looking at me like, not me.
I was like, I don't know, Your Honor.
Sorry.
Not yet, but I'll do it.
Sorry.
You guys know what you want, Your Honor.
You tell me, I will. Okay, so we'll be back in about 10 minutes. Thank you, Reese.
Anybody that has Casey Effridge, could you stick around in the hall?
All right, garnish their wages.
You want, Ms. Etheridge, you want to?
I'm ready, Judge.
Ready? Mr. Powell, do you have yours done?
Waiting on my client to get here, Judge. I called
Okay.
him to meet me right here.
Okay. Come on, Mr. Noakes.
Sorry, I was in.
That's all right.
Ran
That's,
over and,
it's all right. I understand.
Judge, who do you have for me first?
Hold on a second here. Let me pull up your first one.
Oh, yes, I will, it'll get messy, so I'll just, I thought I had an extra, but I'll submit it later. Take it off.
So your
the
first one is Cato, Roy Cato.
Judge,
You want to do that first?
that's fine, Judge.
Okay.
Judge, on Mr. Cato's case, the state and I have been talking about this case, and then Mr. Cato made an offer that I conveyed to the state over the weekend. We're close, I guess is what I'd say to the court. Do we have a date? When's your next?
Well, we've got jury review, which is on Thursday.
Judge, I'd like to try to leave it, just put it on Thursday, and let's see if we can't work over this little hump.
Very good. We'll continue to the November 10th, which is this Thursday.
Okay, at 9 o'clock?
9 o'clock, correct.
Thank you. I'll come talk to you. Who do you got next for me, Judge?
Copeland, Andre Copeland.
President. Judge, I had not gotten anything back just yet from Dr. Harper. My client tells me that he's gone and met with her and signed some papers and what have you in the last few days. So I expect I'll have something by the next pretrial, if we could just move it to the 27th.
We'll continue to December 27th, 9 a.m.
You need to come see me. Still money owed on your case. Okay.
Benjamin Hoffman.
Come see me. Judge, I met with Mr. Hoffman the other day. The state had not conveyed an offer. I was able to get an offer today. If we could just put it on the December 27th so I could meet with him again about the offer.
Very good. We'll continue to December 27th.
Okay.
Mike Mandel, an inmate.
Judge, Mr. Mandel's got 3 cases on the docket. I had met with him and reached out to drug court, and it's my understanding that they had allowed him, or they were allowing him to go and visit drug court. It's a possibility. My client may have more information I don't know anymore. I still haven't got anything more from the drug court lady.
I gotta go Wednesday.
Okay, he's going Wednesday then, so maybe we could just put this on for December 27th with the understanding we might be able to move it up quicker.
Yeah, I mean, if you're able to get something worked out, then just bring it back. We can get on a miscellaneous docket or something.
Okay. Very good, Judge. Thank you.
Shailene Matthews.
Judge, this is another Dr. Harper case, but she hasn't got the workup finished yet, so I'd ask to continue it to December 27th.
Continue to 12/27, but you have had the appointment with Dr. Harper?
Dr. Harper indicated to me that she had gone to the jail to interview her, and then she wanted me to send her some stuff, which I got to her on a flash drive, and so I don't know if she's gone back to talk to her yet, but that's her plan.
Okay, very good. Okay, thank you very much. Tyshawn Morris.
Tyshawn's here. Because we need to continue this. We had depots the other day, and we've agreed just to continue it to December 27th.
No objection.
Continue to 12/27.
Excuse me.
Okay. Maurice Nitsky.
He's an inmate.
Correct.
Wait right here, okay. Give you jail time, so.
How much jail time?
You can put it on for Thursday. You can put it on for Thursday. Talk about it.
Put it on for Thursday, Judge. I think we can resolve it.
Okay.
Can I ask you a question real quick?
Okay, I'll come talk to you at the jail. We're gonna put it on for Thursday, okay? Because I don't know the answer to that question, okay?
We'll continue to November 10th, 9 a.m. Brandon Scarborough. Scarborough.
Mr. Scarborough's present. I did receive a report on his case. Judge, I need to go over that report with him, so if we could put it on, I guess, the 27th.
The 27th?
Yes, sir.
Continue to 12/27.
Call and schedule an appointment and come talk to me.
Yes, sir. Adam Truman.
Reach up here and sign that. May I approach, Your Honor?
May. Thank you.
Your Honor, based upon plea negotiations with the state in 2020 CF 2470, Adam Brock Truman is going to enter a plea in count 1 to a lesser included offense of possession of a controlled substance, count 2, possession of a weapon or ammo by a convicted felon, and then count 3 is a misdemeanor, possession basically of paraphernalia. The understanding with the state is he'll be adjudicated on all 3 counts. He will receive time served on count 1 and count 3. He will receive 36 months Department of Corrections with credit for all time served. That is a minimum mandatory. That will be on count 2. And he has $615 in court cost and a $150 court-appointed legal assistance fee.
That's correct, Your Honor. With this recent negotiation, I will need to redo the score sheet. I did speak to counsel about that, and so I will redo it and submit it.
Okay, very good. Mr. Truman, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Sir.
Okay, you heard your attorney state the terms of the plea agreement. Is that your understanding what the plea agreement is?
Sir.
And I see you've signed the written plea and sentencing form that contains that same thing. Have you gone over this plea agreement with your attorney in detail? Make sure you understand all the legal ins and outs, because there's a lot to this. And then when you waiving some valuable legal rights, the biggest of which is the right to go to trial, right to contest them, force the state to prove their case beyond a reasonable doubt. All those things you're waiving, this is a final adjudication.
Sir.
And you believe it's in your best interest to do that? Why?
Sir, it's just, I don't think with my record, and I don't think I have a chance.
Okay. You believe it's in your best interest to enter into this here today?
Yes, sir.
Very good. And you've had all your legal questions answered by your attorney. You satisfied with your legal representation? Okay. Based upon that testimony, the court will accept your plea here today. As to counts 1, lesser included offense of possession of a controlled substance, and count 3, possession of paraphernalia, the court would be adjudicated guilty and you'll be sentenced for credit for time served. As to count 2, there'll be an adjudication of guilt, sentenced to 36 months. That is a minimum mandatory in the Department of Corrections. You will get credit for all time served. Then the fees and costs will assist legal appointed. We'll probably need to put this, it'll go to collections.
Yes, sir.
Yeah, well, I'm going to ask you to just slip that out. So all the fees and costs will go to collections, okay? Do you have any other questions, sir? Any questions?
Yeah, about they confiscated some money from me in the very beginning. It wasn't much, but like $1,300.
Mr. Nopes?
Oh, Mr. Truman, that we can contact the agency who made the arrest and ask that they release the money. State's position will be, but normally in the past, they say they don't need it for evidence, and they got to wait 30 days past the time for appeal, but then we'll deal with the agency, basically.
Okay. Okay, very good.
What's your address?
It's 9-7.
9/7?
No, 9 Central 7.
Jesus Christ, man.
Okay. You want to do McDonald, Ms. Etheridge? I think that's all you got there, Mr. Nopes.
I do, Judge. I need his address for another
That's all
reason.
right. Take your time. Yes, you can recall McDonald.
Santa Rosa Beach, 9 Central 7th Street. Good.
Ms. Rivers?
Your Honor, I did have an opportunity to speak to Mr. McDonald. I believe it's something that we probably can work out. Our discussion, it has to do with 3 years DOC followed by probation doing a inpatient treatment. However, he'd have to, apply for that.
Yes.
I did talk to him about it might be easier to use the PD to help him apply, but he does not want to do that. He says he is going to try to obtain Mark Welton, see if he can obtain him to help him with that process. He wants to just leave it on for Thursday. Did I get that right? Okay.
Try to get this orderly done.
Okay.
Except for, I will tell you this, based on my past experience, both Phoenix House and Keaton, they take more than a couple of days for an answer, okay?
Okay.
So just so you know that.
For the court's information, we've actually been waiting for several weeks for responses from Keaton and Phoenix House. As of late, we've been waiting several weeks beyond a normal return date. I just want him to know that as well.
So for today's hearing, all we're doing is we're continuing it until just this Thursday, November 10th at 9 a.m.
Yes, sir.
And hopefully you can get a little more clarification and we
Yes, sir.
can get a resolution.
And we did also talk about REAP, reentry program. However, it's not an inpatient. It is a halfway house where you can go for treatment, but it's not inpatient. So I think he does want to talk to Mr. Welton and go over his options.
Yes, sir, I do.
Think you can get them between now and the 10th?
I got a little work to do, Your Honor. I'm gonna go back to the jail and make some phone calls this evening and all, and try to get this stuff summed up for us.
Okay.
All right?
Thank you, sir.
Yes, sir.
We'll see you
Thank
on
you, Your Honor.
Thursday. Is Dixie here, Mr. Powell here? We lose him? Okay. Do we know where Dixie is?
Your Honor, can we approach on this?
Sure, sure. Do we need to approach with the state? Okay. Counsel, will you announce the case?
Yeah, sure. Casey Etheridge and Mr. Dixon. And
You're ready to go. Mr. Powell will do that one. We'll do you next. You got a little more time? You need a little more? Take your time.
we're hearing the,
That's all right. That's all right. Don't worry about it. Just let us know when you're ready. Okay.
we're hearing the 2018 CF 2695, 2019 CF 562, 2019 CF 1659, 2019 CF 1660, 2020 CF 835, and 22 CF 1506. And Your Honor, this was set, plea or continue, and Your Honor, we're asking to set this on the December 29th docket, potentially for a plea, or we'll set it for a contested hearing at that time.
How about December 28th? For
Is
the
there-
inmates?
Well, that's the pretrial date. I was hoping for the criminal motion, or miscellaneous criminals, if they're one on the 29th.
Okay. If you want to do it then, that's fine.
Is there a way I can handle it, make a deal today?
Sure.
If I was to.
Absolutely can make a deal.
If I could talk to the state?
Sure.
He offers 56 months in prison.
What if we separated the charges with the violation?
If you want to chat, we can pass on this and come back. We're going to be ready to take a break in a half an hour or so for lunch, so you can sit. I think the state's, I don't want to get in the middle of it, you know.
He offers 56 months, DOC.
Credit for all time, sir?
All the time that you're entitled to, yes.
What, all
You
that?
always get all credit for time served.
Credit, 56 for everything?
For everything, and she said it could
56
be,
for everything.
you
Wait,
said it's
credit,
under credit on, the highest credit on that.
so I get credit for every violation? I couldn't get credit for every violation?
You do, but you
Whatever
don't.
time you have on each case, you'll be entitled to that time.
But it doesn't stack, so it doesn't add it together.
What is my adjustment short sheet then? When you went to mark and stuff, what is that? What is it? What's the time with that then?
Well, you can plead to the court for that, but we don't know who the judge is gonna be. So, if you wanna do that, we can, but we don't know who we're
I'm just
gonna.
asking what my time will be with my adjusted score sheet. You have not brought that, you have not. when
Because I don't have an adjusted score sheet. I have it with all the cases.
I've been here 5 months and you have not.
We just
All
talked
right,
about
Your
this the
Honor.
other day.
I was,
What are we doing?
I ain't got no choice but to continue this right now.
I mean, if you would like to plead, we can do that with the adjusted score sheet.
I would like to know what my points is with my adjusted score sheet, what the offer would be with my adjusted score sheet.
Leah, do you know what his points will be on just the VOPs at all?
No. I just have a global offer.
You don't have a, yeah.
So what do we need to do? You want to come back and see if you can get a little?
Yeah, can I do that to see what the offer would be then?
I'm not going to make an offer
She's not
that
gonna make
doesn't
an offer.
include all cases. Right?
Okay,
So
what
you'd
can I
have to plead to
see?
all of them if you want to take the state's offer for 56 months in prison, and it can be You can get all of your credits, right, that you already have on those cases.
But what the adjustment score sheet, what is that? What do I score
I
to
don't know what
then?
you mean by adjusted score sheet.
It's not going to change because she's having you plead all of it. She's not going to give you a piecemeal like we talked about at the jail. She's not doing piecemeal for just the VOPs. She's for 56 months for all of it, or you can plea straight up and we'll get a score sheet on this, but we don't know who the judge is going to be. So that's the reason that we're trying to see who the judge is going to be. Yeah. I mean, do we know yet, Your Honor? Just for our benefit, do we know who the judge is going to be?
But I don't think you're supposed to
What?
accept a plea based on whoever the judge is.
Well,
Thank you.
I mean, it's not really that.
You
Your
don't
Honor.
want me to be the judge, but for a plea
Well,
to
it's
the
not
court, but,
that, yeah.
no, you can't,
Yeah, I just don't want to.
I just want to know.
we don't know. The answer to your question, we don't know.
With,
If it's in the next few months, it will probably be a senior judge. One of the
well, what do you
very
mean
experienced
about
judges out of Pensacola. will
all
be
my
coming over.
time, like on all my cases, so if I took 56 for everything, I don't get on 2019, I don't get the 398, and the other 2019, I don't get the 398. I don't get all that time
You would.
towards,
You would.
It just doesn't stack on top of each other. Yeah.
it doesn't stack on top of each other?
No.
Right, it doesn't add up, but yes. So on 2019 CF 562, if you had 398 days credit, you would get that credit. You'd have more now because more time has passed, but you would be entitled to all of the credit that you've previously accumulated on the other cases.
Will they go towards the 56, is what I'm saying, too?
Yes.
I'm not understanding. Will they knock it down, or would it would just be going on the 463?
So it's going on the 463, because you're going to be released, yeah.
I just would like to know what I'll adjust to. We'll do that, we'll continue then, and then
Okay.
try to come up with something.
I'll try to get an adjusted score sheet. Okay. If we could set this on the 12/29, I believe it is, Your Honor.
Very good.
What happens
Continue
with
to
the-
12/29.
You call her, she says she comes that same week. I'll
Okay,
talk to
well,
her.
then she'll come next week, yeah.
Dallas Dodd. Oh, did Mr. Powell? He's still got a few minutes.
Casey Etheridge for Dallas Dodd. And Your Honor, we've been given some information about some potential witnesses for this case, so we'd be asking for a continuance.
How did this change? We had a plea or trial on our last
I know.
hearing. So we
'Cause
got
I
another,
spoke with-
we got new witnesses?
I spoke with Mr. Dodd again, and he had told me that there were some witnesses that have not been, and we haven't disclosed them, so yeah, I need to
A
speak with
year
them. I don't know
ago,
what they're
so
gonna
over
say.
last year, you're not just coming up with witnesses?
Well, I mean, this, Your Honor, to be fair, there was an FTA on this case. It's not been a year. This is the.
Okay, well, I know you work your
I'm just letting you
cases.
know, it's like, it's not, yeah.
Well, but I mean, that's all I've got, so I have to
Right.
look at that.
And so
but-
it looks like that there was an FTA in like February, early February this year, and then he didn't come back again until August or something like that,
Yes,
August.
yes.
We'll continue to 12/27.
Thank you, Your Honor. You need to get me that other witness.
Shelley Ann Edwards. On at least one of your cases, we can go to trial this week. Ms. Evans.
Yes, Your Honor. I will on, Your Honor, we haven't gotten there yet. Your Honor, Casey Etheridge for Shelley Edwards, and Your Honor, I believe that, she is actually, I'm not sure why she was put on this docket. This was, supposed to be on the pretrial conference date. I did waive her appearance today. And she's out of custody, so I would just ask if we set this on 12/27 for pretrial.
She wasn't supposed to be on this one today?
She wasn't set for trial or anything. This is a new case. It was the first time up, so
Okay.
I'm not really sure what
12/20
happened.
Continue to 12/27.
Thank you.
William Ewing.
Casey Etheridge for Mr. Hewing. We're here in 2021 CF 1763 and 2021 CF 1877. And Your Honor, We're ready for trial. I believe the state would like to go on 2021 CF 1763.
That's correct, Your Honor.
What are we anticipating as far as time?
One day.
Okay. Very good. Okay, so we'll come back on November 10th, jury review, and go over what we need to do. Terrell Flournoy.
And Your Honor, can we just set the other one, a tracking with it? I just want to make sure that we're.
Sure.
Thank you.
Both, 21 CF 1877 Ewing will also be tracked together.
Thank you.
November 10th.
Casey Etheridge for Terrell Flournoy, and we're here in 2022 CF 1603. And Mr. Flournoy would like to withdraw his previously under plea of not guilty, under plea of no contest, accept the state's offer. For count one, it would be adjudication of guilt, credit for time served, $767 in court costs, $100 cost of prosecution, $150 in public defender fees. And on count two, adjudication of guilt, credit for time served, all fees, fines, and costs reduced to judgment.
And that would put me getting out today, correct, Casey?
Yes? Mhm.
All right, I'm just making sure. Plugging home for, huh? All right. So, Your Honor, with entering this plea, I'm released today on my own recognizance.
That's correct, yes.
I don't know,
All
I
right.
I have to look at the plea.
Yeah.
Thank you.
First I've seen it.
Yes, sir. Just wanted to be sure, Judge. I thank you, sir, for your time. You have a good day.
Hold on.
Well, you gotta wait, you gotta enter the
Okay.
plea
I get
first.
to ask you a few questions.
Okay, yes, sir.
Hold on.
Yes, sir.
I got to get a copy of the plea agreement.
Yes, Your Honor, I apologize, we're having.
Thank you. Want to announce the agreement, please?
Yes, Your Honor. He would be entering a no contest plea and accepting the state's offer of adjudication of guilt, credit for time served, $767 in court costs, $100 cost of prosecution, $150 in public defender fees, and on count two, adjudication of guilt, credit for time served. All fees, fines, and court costs be reduced to judgment.
Score sheet,
No objection to the score sheet.
downward departure, counsel.
That's correct, Your Honor. It's a legitimate, uncoerced plea.
Mr. Flournoy, would you please raise your right hand, sir? Do you swear
Yes,
or
sir.
affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Heard your attorney state the terms of the plea agreement.
Yes, sir, I did.
Is that your understanding of what the plea agreement is?
Yes, sir.
You understand that by entering this plea, you're waiving the right to go to a trial. This will be a final adjudication of your case?
Right, and that will release me to the streets today, right, Your Honor?
Unless
I
you have
believe
another
that will
case.
release you to the streets today. This is for credit for time served.
I'm just making sure.
No, I understand. Got all your legal questions answered about this?
Absolutely, absolutely.
Okay, very good. Based upon that testimony, the court will accept your plea, be an adjudication of guilt on both counts, be credit for time served on both counts. Standard fees and costs that are contained in the plea agreement, those will be reduced to a judgment.
All right.
Thank you, sir.
God bless you.
You too. Yuquay Wesson.
We already took care of her this morning, Your Honor, with a plea.
I thought. Gafford, Matthew Gafford.
Casey Etheridge for Matthew Gafford, and we're here in 22 CF 612. May I have one moment?
You may.
We're ready for trial, Your Honor.
Okay. What are we looking at for this?
One day? Yes.
Okay. Come back on November 10th, 9 a.m.
Thank you, Your Honor.
for jury review. Thank you. Romero Garland.
Your Honor, KCFH for Romero Garland, and Your Honor, I got a message from my legal assistant that Mr. Garland's car broke down in Jacksonville on the way here. He lives in Georgia. If we could reset this for jury review, he was going to plead a PTI today, and he just can't make it because his car broke down.
Come from Georgia through Jacksonville.
Yes. I guess the interstate he was going to get on 10 is what I'm understanding.
I guess you can go through Georgia to get to Jacksonville.
Hmm.
Okay, State.
State has no objection, Your Honor.
So when do we want to come back?
If we could come back on jury review, that would be great, so we can resolve this case. I mean, he was going to I think we had set this plea or trial, so I didn't want to put the state in a
Let's do it.
position.
November 10th for plea.
Thank you.
Okay. Thank you. Harrison, Chadrick Harrison.
CF Ridge for Chadrick Harrison, and we're here in 2021 CF 1024. I believe that was the only case that was set for today. And Your Honor, the state has set a deposition of the defense witness, and I believe it's on November 28th, I believe, after our jury trials. So we're asking for a continuance, I suppose, on that.
We'll continue this to 12/28. Depositions, November 28th. Okay. Haynes Ashton.
KCF Ridge for Haynes Ashton. We're here in 2021 CF 1483 and 2021 CF 1864, or 46, I apologize. Your Honor, in this case, we are close to a resolution with the state. I believe the state needs to talk to one more victim, so we're asking to set this for December 1st for resolution. We don't believe this is going to be a trial at all. So.
We'll continue to December 1.
Thank you, Your Honor.
Very good. Thank you. Mr. Powell, you ready?
Yes, sir, Your Honor.
We take just, you can just leave your stuff right up there, Mr. Etheridge, unless you want to move it.
Oh, I'm good. Oh, I'll move them. Thank you.
Thank you for your patience. All right, let's see. Rebecca Thomas.
Yes.
sir.
Oh, sorry. Dixie Dan Powell on behalf of Rebecca Thomas. Your Honor, we have a plea agreement worked out. May we approach?
You may. Score sheet, thank you very much. Would you announce the terms of the plea agreement, Mr. Powell?
Yes, sir, Your Honor. Under case number 2022 CF 1415, defendant Ms. Thomas pleads no contest to count 1 as charged. Adjudication withheld on count 1, sentenced to 12 months probation with drug evaluation and treatment if necessary, random year analysis, 15 hours community service, that we can buy that out. Standard fines and court cost of $515 and $100 cost of prosecution, early termination upon completion of all requirements.
Now, just a couple points of clarification. Do we need to put in the plea agreement if you can buy out the community service hours?
Probation's perspective, yes, sir, and we need the amount. It's usually $10 an hour.
Okay.
Can you
I'm going to
write
ask
that
you
in?
to add that little thing in there, and then
Can you do that for us, Judge?
I try not to
Okay.
mark this thing because I keep my fingers off because I don't want somebody to,
I guess.
yeah, here you go.
Yeah, can you do it?
You had one other thing that wasn't on there, that
Early termination.
early termination.
It's on the special condition. Special, it's under special conditions on that. Right here, page 3.
It's not automatic, though. You need to just put
Okay.
on here in this one right here. This is
Officer
the signed one.
requirements upon application. My apologies, Your Honor, it's a Monday.
Believe me, I know. I was duty this weekend, so it definitely feels like a Monday. Okay,
You
great.
understand we made the changes
Yes.
that you get to buy these out at $10.
Early termination upon application.
And the, an early termination upon completion of all requirements and application for it.
So, Ms. Thomas, I just need to ask you a few questions. Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney, you can put your hand down. You heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is as well?
Yes, Your Honor.
I see that you've signed the written plea and sentencing agreement. Have you, and that contains the same thing, have you gone over this plea and sentencing agreement in detail with your attorney? Make sure you understand all the legal ramifications, because a lot of legal stuff going on here with this. You're waiving, importantly, you're waiving some valuable legal rights, the right to go to a trial, the right to contest this, limits your appeal, all those things. You believe it's in your best interest to enter into this plea agreement?
Yes, Your Honor.
Okay. And you're obviously satisfied with your legal representation?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement, and the defendant will plead no contest as charged. Adjudication will be withheld. You'll be sentenced to 12 months probation. Importantly, you'll have to get a drug evaluation sooner than later. Don't wait until the end of that, okay? Because then you're going to be pushing the end of it, and you'll be possibly violating, and you don't want to violate probation because you can come back in here and it might not end well, okay?
Okay.
So, in addition, there's 15 hours of community service, and you can buy out, and there's standard fees and costs. You can get early termination as stated if you go a certain amount of time and you don't have any violations, okay?
You.
And the score sheet, you're okay with, Mr. Powell?
Thank you, Your Honor.
Very good. Thank you. You have a nice day.
Supervision, please waive, Your Honor.
Yes, sir. Thank you. Martha Hoffman.
Casey Etheridge for Martha Hoffman, and we're here in 22 CF 640. She would like to enter a no contest plea and accept a PTI referral from the state. I did provide probation with the agreement, and then I have a written plea agreement as well. May I approach?
Great. Yes, ma'am. Thank you. So, Ms. Hoffman, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So there's a pretrial intervention program. Have you gone over this, the terms of the pretrial intervention program with your attorney? Make sure you understand it.
Yes, Your Honor.
This will be a condition is essentially a condition of probation, this PTI referral? Is that how we're terming it, Ms. Etheridge?
Yes, Your Honor.
Okay. So you do have a right by entering into this. You're waiving the right to go to a final hearing, a trial. I believe it's in your best interest to do that.
Yes, Your Honor.
If you're not able to succeed in this pretrial intervention program, would come back. So you might have to deal with this again if you can't succeed on that. Do you understand that?
Yes, Your Honor.
You've gone over all these different terms.
Yes, Your Honor.
Is there a DCF case ongoing with this?
Not right now.
Oh, sorry.
Was there previously?
I believe they made contact, but I don't think it ended up as any, did you have to do anything? No. But if there is, then she'll comply with whatever there is, so, if there turns to be one, so.
That's unusual to have a criminal charge without DCF.
So,
Who knows?
and Your Honor, I believe they made contact with them, like, so they have made contact. I just don't think there's anything ongoing at this point. This case is a little older too, Your Honor, so. And so,
Okay, as long as we're all clear, that's what's important. Okay. Very good. Based upon that, the court will accept your plea, and you'll be referred for the pretrial intervention program based on the terms contained therein. Good luck.
thank you, Your Honor. Thank you.
Jose Hooker.
Casey Etheridge for Jose Hooker, Your Honor, and we have not had any contact with Mr. Hooker since like almost right before pretrial, and so we've made a lot of efforts to get a hold of him. We've left messages to be here today, and so I mean, however Your Honor would like to handle that here. So
State requests capias, no bond.
So granted. Jonathan Johnson.
Okay. Casey Etheridge for Jonathan Johnson, and we're here in 2021 CF 1255 and 2022 CF 83. And Your Honor, we're ready for trial, and I believe the state is intending to go forward on the 2021 case. Is that correct?
I believe so, Your Honor. These are Ms. Barrickman's cases, but I believe it is 21-1255.
But either way, Your Honor, we'll be ready for trial. So,
And I'll have
Okay.
Ms. Barrickman confirm that with you tomorrow when she gets back.
Sure.
Okay, November 10th at 9 a.m. on jury review.
Thank you, Your Honor.
And is Mr. Johnson rejecting all previous offers, then?
Mr. Johnson, okay. The state wants to know on the record that you're rejecting their offer?
Yes, ma'am.
Okay.
Thank you very much.
Thank you. Colton Keaton.
Casey Etheridge for Colton Keaton, and Your Honor, we would like to leave this sit on jury review. We believe we may have a resolution, and Mr. Keaton needs a little bit longer to consider his I guess, position, I guess. And I don't believe we're going to be ready this cycle to go on this case anyway, so if we could do that.
We'll come back. I'm sorry.
And Your Honor, the state has no objection if the court would allow that. We believe we do have a resolution, but I know Mr. Keaton.
Okay, we'll come back November. You want to do it November 10th or?
Yes, Your Honor. if
That's fine,
acceptable
please.
to the court.
Okay.
Thank you.
Very
So
good.
it's Thursday. Okay.
Thank you. Dvorak.
Casey Etheridge for Bradley Kovaric. We're here in 2021 CF 3026, 2021 CF 2021, and 2022 CF 983. And Your Honor, we would be asking to set this for the December 1st docket. These are two VOPs, and then depending on the resolution of that date, it may be set for a contested hearing at that point. Christine, that's what we talked about.
Plan was to do the VOPs ahead of time, yes. Okay.
Right, well,
We'll do it for
well,
December
correct,
1st.
yeah, yeah.
So we'll come back December 1st and deal with the VOPs.
So, yeah, so on the morning docket on the 1st, and then we'll reset for a contested hearing, if that's fine.
Sounds
Okay.
good. Just
Okay.
coordinate with Ms. Barrett.
Correct, yes.
Very good.
Okay.
Tabitha Rents.
And Your Honor, I did have one more once you have Ms. Rentz.
Which
It's a
one?
recall,
You
but we
got
can
it.
do Ms. Rentz first,
got
it
it.
doesn't matter.
Let's do your case. We'll do
Okay.
yours.
Joshua Brewer.
Which one was
Your
it?
Honor, he just has to go sign it for PTI. Joshua Brewer.
Brewer?
Yeah, we had handled this earlier, but he needed to sign a plea agreement for
Right,
PTI.
Right.
We're here in 2022 CF 2227. This is Joshua Brewer, and he would like to enter a no contest plea and accept the state's referral to PTI. He's already signed up. He just needed to do a plea agreement. May I approach?
State has reviewed that, Your Honor. That is our agreement.
Okay. Mr. Brewer, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sure.
And you understand that this PTI referral is part of the plea and sentencing agreement that you've entered into?
Yes, sir.
You've gone over this agreement with your attorney, make sure you understand all the terms of it?
Yes, sir.
Importantly for this, did we already turn in the PTI?
Yes. If probation has it.
That pretrial intervention has, a list of things that if you fail to conform with that, you'll have to come back and deal with these charges. Do you understand that?
Yes, sir.
And you understand that if you complete those, it'll be a final resolution of this case?
Yes, sir.
Do you have any questions concerning this matter?
No, sir.
Okay, very good. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Etheridge. Rents.
Your Honor, Tim Gibbs on behalf of Tabitha Rents, 19 CF 1881, 22 CF 1765. We're asking to continue this to the next cycle.
No objection, State?
No objection, Judge.
12:27, 9 a.m.
Thank you.
Miguel Nobles.
Tim Gibbs for Mr. Miguel Robles in 22 CF 1213. We had a waiver on file for pretrial. However, I overlooked the fact that he was going to try to request by Zoom, therefore I did not file the motion. I spoke with Ms. Glisson. I believe we both are in agreement to continue this to the next cycle.
Objection.
We'll continue to 12:27.
Thank you, Your Honor.
Kenneth Stewart.
Tim Gibbs on behalf of Kenneth Stewart, 22 CF 2207. Your Honor, he is present and approaching. We are requesting to continue this to the next cycle.
Continue to 12:27, 9 a.m. Stay in touch.
We'll talk in the meantime, get another appointment.
David Tenorio.
Your Honor, Tim Gibbs on behalf of David Tenorio, 22 CF 1902. Your Honor, Mr. Tenorio is going to enter a no contest plea this morning, withdrawing his previously entered not guilty plea. The sentence would be as follows. He would have a withhold of adjudication on the single count of possession of controlled substance, receive credit for time served, a $100 cost of prosecution, $515 in court costs, $150 public defender fee due within 180 days. If I may approach with a written plaintiff's score sheet. No objection to the score sheet.
Thank you.
That's the agreement, Judge.
Mr. Tenorio, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement.
Yes, sir.
Is that what what you're agreeing to?
Yep.
And the plea and sentencing agreement, I see you've signed it, you've gone over all the legal details of this, had all your legal questions answered about this plea agreement.
Yes, sir.
You understand that you're waiving some valuable legal rights. Just want to make sure you're doing it freely and voluntarily. Right to go to a trial, right to contest this, force the state to prove their case beyond a reasonable doubt. You're waiving all those rights. Do you understand that?
Yes.
And you believe this is in your best interest to do this? Do you have any other questions of your attorney? Okay, very good. Based upon that, the court will accept your plea. There'll be a withhold of adjudication on the no contest plea and on possession of a controlled substance, so you'll get credit for time served, fees and costs payable in 180 days, or it goes to collections, okay?
Thank you, Your Honor.
Thank you.
Good luck.
Is the defense okay with the score sheet?
No objection, Judge.
Thank you. Otis Terry.
Your Honor, Tim Gibbs on behalf of Otis Terry in 01 CF 1929, 21 CF 1613. Your Honor, if I may have just one moment. So we went over all those terms. I just need you to sign right there. I just need to add in that it is a downward departure. Yeah, but it's to get up. Your Honor, the terms of the agreement in these cases, Judge, he has two cases. The first is a VOP, or both of them are VOPs. The first has three counts in it, and 21 CF has one count in it. However, for all of these cases, counts concurrent, there is still a 5-year suspended sentence that is going to remain suspended. For these counts, he's going to be placed on 5 years of probation. He needs to enter and complete the Adult Teen Challenge Mid-America Rehabilitation Program that is in Cape Girardeau, Missouri. For the duration that he is there, he is going to be on mail-in probation. He needs to enter that program within 72 hours of his release, and he needs to return to Okaloosa County within 72 hours of completion of that program, whether it is graduation or any other way that he may end up leaving that program. The Jessica Lunsford Act does require that he also be on a GPS monitor as well for the duration of his probation. He will need to be fitted with that before he is released. There would be a $200 cost of prosecution, $250 public defender fee, waiving the cost of supervision while he is on supervision, and this is a downward departure plea due to the fact that he does score a presumptive prison sentence. If I may approach with this written plea.
And Your Honor, the state has reviewed the totality of Mr. Terry's violations and the circumstances. He does wish to seek treatment, believe it's appropriate. It was the basis for his violations, so we do agree to.
Mr. Barry, do you have some questions? You looked
Yes, sir.
interested in this case.
That's above my pay grade right there. If you can give me a moment and let me contact Mr. Wilkinson at the office to see if this is feasible. Because if he transfers to, number one, he's going to be on GPS.
Right.
Period. Number two, I don't know that they're going to accept him on GPS in Missouri.
We're not transferring his supervision.
If he's over there, we are. We'll call. Can we do that?
Absolutely.
Uh-huh.
You want to, yeah, let's just pass on this, and we'll come back to it.
Okay.
Can I look at that?
Yeah, let me hand this back to you. You
And I
can.
can run that by Mr. Wilkinson.
We just want to make sure we can actually do what we're
Okay.
trying to do. I appreciate everybody trying to be creative, but we need to.
I'll
Yeah.
send this to.
Can we pass over? Why don't you head back in there just for a little bit, and then we'll come back.
All right.
Truder. And Mr. Williams and Mr. Russell, unless you don't want to, let's go ahead and we'll push through here and just finish this thing this morning. We're not.
Fine, Judge.
Not worried about lunch. People are waiting. They've been waiting all morning. Yes, sir. Unless are you okay with that?
Yes, sir, mine won't take long.
Okay. You just have the one case, Mr. Williams?
That's correct, Judge.
Okay, we're going to do yours after this one, okay? Sorry. I always keep forgetting.
Judge, I have to be someplace. Might as well be here, and I did bring work with me, so
Okay.
I've been working.
Mr. Gibbs.
Thank you, Your Honor. Tim Gibbs on behalf of Luke Truder, 22 CF 1121, 22 CF 1430. We're asking to continue this, Your Honor, to 1228.
No objection, Your Honor. We discussed this one, Your Honor.
Continue to 1228.
Thank you, Your Honor. So we'll try to get that worked
Let's do Marquise Davidson.
Marquise Davidson.
Joshua Marquise Davidson. That's
Judge.
the last one. No, he's not an inmate, I'm sorry.
No, he's not an inmate, Judge. It was passed last time. He was not in court. He provided medical records showing that he'd been diagnosed with COVID.
Right.
So it was reset for today. I tried to call him Friday, could not personally get in contact with him. I left a message for him. He called sometime between then and this morning and advised that he was ill and was not going to be in court today. My legal assistant tried calling him back and could not get him on the phone. So I don't know what to tell the court other than on his behalf. I don't know that it's useful to pass him for another 2 weeks. What I would request is let's go ahead and continuing the full docket. And that way we can keep trying to get a hold of him and try to get it resolved.
State would request that he be here on the 10th.
I have sent him, I'm able to type up and send letters from here. I've sent him a letter telling him he needs to provide us with proof of his illness.
We'll come back on the 10th. He's either going to have proof or he's going to be getting capious.
And I will follow up with that, Judge.
Make sure it's good proof too, not some scratch thing papers.
I'll do what I can, Judge.
I
My
understand you can
background
only
is
do that.
EMS,
No,
so-
I understand that. Okay. Very good. So we'll come back on November 10th.
Yes, sir. Thank you very much.
Okay. Thank you, Mr. Williams.
Yes, sir.
Thank you.
Vernon Webb.
Tim Gibbs on behalf of Vernon Webb, Your Honor, 22 CF 2054. If I have just a moment. At this time, Your Honor, we request to continue this to next cycle, 1228. I do know that he has a new case that I think is set for plea day on the 1st, but I'd like to just go ahead and leave that case set there in the event that we may be able to resolve it or address anything else that needs to be addressed.
There is no objection, Your Honor, and as Mr. Gibbs mentioned, if we can get them both resolved earlier together, then we will do so.
Absolutely.
Thank you. Continue to
When will it be?
12/28.
December 1st is when we'll be back for plea day on the new case.
Ebony Williams.
Yeah, we'll talk about it and see what we can try to do. Your Honor, Tim Gibbs on behalf of Ebony Williams. She is present and approaching. 21 CF 2986, 21 CF 2987. Speaking with the state, we'd like to go ahead and continue this one last cycle. There's just some last few details I think that we're working out.
It's a restitution issue, Judge, so no objection. We'll get that restitution number and we should be set to
Very good.
plate.
Continue to 12/27, 9 a.m. Stay in touch with your attorney, okay? Desiree Lige. Desiree.
Charles Russell, Public Defender's Office. Ms. Lige is present and approaching. Case number is 22 CF 450. Ms. Lige's case, Judge, at this time, we're asking for a continuance so that we can complete discovery.
Continue to 12/27.
Your Honor, can I please bring something to your attention?
Mention it to your attorney. I don't want you to say something that might hurt your case.
He's fine, Judge.
Okay. Christopher Majors.
Mr. Majors is present and approaching, Judge. It's case number 22 CF 2293. This is Charles Russell, Public Defender's Office. It was passed for a plea, Judge. In exchange for a plea of no contest, the agreed upon sentence will be an adjudication withheld. He'd be sentenced to time served, pay court costs, $100 cost of prosecution, $150 public defender fee, and he would have 120 days from today to pay, or it would go to judgment. May I approach, Your Honor?
That's the agreement.
Thank you.
Sheet, Judge, and we agree with it.
Very good. Mr. Majors, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is?
Yes, sir.
And I looked at your written plea agreement. It's got your name on it. You've gone over this with your attorney, had all your questions answered, your legal questions.
Yes, Your Honor.
And importantly, you're waiving some valuable legal rights by entering into this plea, the right to go to a trial, force the state to prove their case. You comfortable? You believe it's in your best interest to enter into this plea?
Yes, Your Honor.
And you've had all your legal questions answered by your attorney?
Yes, sir.
Okay. Very good. Based upon that, the court will have a withhold of adjudication on all three counts?
Yes, sir.
Okay. And you will get credit for time served. There'll be some standard fees and costs payable in 120 days, or it'll go to collections.
Yes, Your Honor.
Any questions?
No, sir.
Okay. Thank you very much. David McQueen.
Charles Russell, Public Defender's Office. Judge, this is David McQueen. He's present and approaching. Case number is 21 CF 1989. At this time, Judge, we're going to announce ready for trial.
Just speaking to Mr. Gibbs about a possible plea, but sure, we're ready.
This one?
On this one?
That's, we were talking about earlier about the offer.
I-
Or you were asking me about it. Okay,
I-
we're good to trial.
But I discussed the offer with him that you and Mr. Gibbs had talked about, and he does not want to accept it.
How long are we talking about here, a day?
It's a traveler case, Your Honor, it's a day.
It's a what?
It's a day, Your Honor, it's a traveler case.
And when you're asking how long, Judge, you're talking about from jury
How long
selection
did you
to-
anticipate the
to
trial?
closing, jury selection to closing, because we're doing a pick and go?
We'll go pick and go.
Okay, I think a day's reasonable, Judge.
November 10th at 9 a.m. for a jury pretrial, jury review, excuse me. Larry Jack Miller.
Mr. Miller is present and approaching, Judge. Case numbers are 20 CF 2060 and 20 CF 2061. On 2060, Judge, we're asking for a continuance to the 1227 docket. There's a deposition still to be taken. And on 2061, defense is ready for trial. We had filed a motion to unseal the testimony given at the Williams Rule hearing. The state indicated that they had no objection, so if the court is agreeable, I'll send over an order.
The state is ready for trial, Your Honor, and we have no objection to that being unsealed for the purposes of transfer.
Very good. How long do you anticipate this taking?
Exclusive of jury selection, Your Honor, I would say a day.
Judge, I'm going to say, including jury selection and all testimony, probably 2 days.
Accurate.
Okay.
The November 10th, Judge, on 2061? Okay. See you Thursday.
Okay. November 10th. Shane Mole.
Mr. Mole is present and approaching, Judge. Case number is 21 CF 2147. If I could have a moment, Judge. Judge, at this time on Mr. Moll's case, we're asking for a continuance to the 12/28 docket. We are waiting for an approval from Phoenix House. If we get one before then, we can move him up sooner.
Very good. We'll continue to 12/28.
12, December what?
28th, after Christmas.
Thank you. Oscar Moody.
Moody is present and approaching. Judge Charles Russell, Public Defender's Office. His case numbers are 19 CF 1444 and 22 CF 541. The 2019 case is a violation of probation, and the 22 case is our new law charges. We've reached an agreement with the state. We are admitting the violation of probation in the 2019 case and pleading no contest to the charges in the 22 case. On 19 CF 1444, the sentence will be an adjudication of guilt, revoke and terminate that probation. He would pay a $100 cost of prosecution and a $150 public defender fee. Any monies he owes in that case will be paid as a condition of the probation and supervision in the new case. On count 1 of 22 CF 541, which is a felony possession of controlled substance, it will be an adjudication of guilt. It will be placed on 6 months community control, followed by 24 months probation. Cost of supervision will be waived. He will pay court costs, $100 cost of prosecution in that case, and should be a $100 public defender fee in that case. He will be subject to random urinalysis. He can have no drugs or alcohol without a prescription. He will complete an intensive outpatient substance abuse treatment program. He shall enroll within 30 days. He can apply for early termination after 15 months if there are no violations and he's completed the terms. Count 2, which is a misdemeanor, it will be an adjudication of guilt and time served. May I approach, Your Honor?
That's the agreement.
State.
That's the agreement.
Very good. Mr. Moody, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Moody, you heard some detail, your plea agreement.
Yes, sir.
And I see that that same plea agreement that was announced by your attorney is contained in the written plea and sentencing agreement that you have signed. So, 2 questions. One, is that your plea agreement? Are you good with it?
Yes, sir. I'm fine.
And have you been able to go over this plea agreement, not only the terms, but also all the other boilerplate, important stuff that's in here about waiving rights, your right to go to a trial, this is a final adjudication, all of those things? Have you
Yes,
gone
sir.
over all that with your attorney? Make sure you understand that and are comfortable with it?
Yes, sir.
You believe this is in your best interest to enter into this
Yes, sir.
plea?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. On the VOP, there'll be an adjudication of guilt, revoke and terminate, some fees and costs you have to pay in the other case. Everything in this case will be payable in the other case that's a probation case, 22 CF 541. Count 1, there'll be an adjudication of guilt, 6 months community control, followed by 24 months probation, waive the cost of supervision, court costs and fees. Then you got the standard random urinalysis, no drugs, complete intensive outpatient substance abuse treatment, enroll within 30 days, and if you're able to, you can terminate early after 15 months of no violations and terms completed. Count 2, which is possession of paraphernalia, is just credit for time served. Any questions to any of that?
Yes, sir.
Okay. Thank you very much. Community control, a lot more supervision. You willing to abide by that? Yes. Okay. Seth Talbot.
Mr. Talbot is present and approaching. Judge, case numbers are 20 CF 2428, 21 CF 2077. On his cases, Judge, we thought we could get approvals back from the rehab programs, but we did not get that in time. So right now, we're just going to ask for 12/27. If we get approvals, then we may bring it in earlier.
Okay,
No objection.
very good. Continue to 12/27, 9 a.m. Now, we passed over Otis Taylor. Were we able to, that worked out? Mr. Gibbs?
Yes, Your Honor, thank you.
Marnie, can we get one, Mr. Otis Terry? I think it's the final.
Your Honor, Tim Gibbs on behalf of Mr. Terry, 01 CF 1929, 21 CF 1613. Back on the record for Mr. Terry after our issue earlier. If I could just have one moment. He's initially next to the modification to the sentence that was previously announced, Judge. That modification is, of course, instead of the program in Missouri, he will be entering and completing the intensive outpatient program here at Bridgeway. He will need to enter or enroll within 24 hours of his release from jail. I do want to thank our probation officers for helping to assist in that, as well as, of course, the state in agreeing to this. Just expressing my frustration with the situation that while we could have had an inpatient situation for him, we do at least still have an outpatient program.
And Your Honor, to be clear, we did review it, and it does still include the GPS monitor as well as is. Along with the suspended sentence.
What's the suspended sentence?
Your Honor, it was a 5-year suspended sentence.
DOC remains suspended.
Yes, sir.
That was a previous suspension.
That is correct. This was a VOP, Your Honor. Even though we're on a docket day docket, this was actually a VOP. We were just trying to get it resolved in a timely manner.
And this is a downward departure
It is, Your Honor.
based on?
Your Honor, based on an uncoerced plea agreement, but additionally, Your Honor, the totality of the circumstances, his violations were drug-related. He was, in other words, in compliance. He was working. He was doing everything he was supposed to do. So we'd like to give him the opportunity to get the treatment that he needs to seek.
Okay, very good. Mr. Terry, would you raise your right hand again? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So based upon some discussions about what we can and can't do in different states and whatnot, change your plea, okay? Both parties are in agreement with it. In both cases, there'll be the DOC 5 years still remains suspension, but you'll get 5 years probation, enter and complete the intensive outpatient program at Bridgeway. And you got to enroll, or at least seek enrollment, or set appointment within 24 hours. They don't want you dragging your feet. It's just going to give you more of an opportunity to get in trouble. Really, I mean, that's what we're trying.
I agree with you.
We're trying to, we really want you to be successful. It doesn't do any good. We've got enough people in jail.
I'm 49
Right?
years old, and I'm ready to be successful.
No, I mean that in all sincerity. We want you to be, and our people at probation work hard to try to support that. But this is not easy. It's easy for me to get up here and preach it. You got to make these changes, do that, and turn your life around. Actually doing it, heck, we can't even keep on our New Year's, resolution to go on a diet for 30 days. Let alone change your life. But asking you to change your life, you got a little higher stakes though. So hopefully it'll take, and want you to give it your best shot. So by doing this, you understand you're waiving some rights to contest all this, and you believe it's in your best interest to do this. You've had all your legal questions answered of your attorney.
Yes, sir.
Satisfied with your representation?
Extremely.
Okay. Very good. Based upon that, the court's going to accept the plea agreement. The 5 years DOC will remain suspended. We're starting a new 5-year probation, entering complete intensive outpatient program. And importantly, there is a GPS monitor throughout this. And then cost and fees will go to collections. Well, no, they'll be during the term of the probation, and waive costs of supervision. Got 24 hours to enter the intensive outpatient.
Thank you, sir.
Okay, good luck.
Thank you, Your Honor.
Mr. Gibbs.
Thank you.
Your Honor?
Yes.
We request to remain in custody until the GPS is attached.
Correct. Thank you.
And they enroll in IOP 24 hours from release, because we may not be able to get out there till tomorrow.
Sure.
Yeah, like that.
Okay,
And that was the intention. Thank you, Mr. Berry.
thank you.
Good luck.
Okay.
Oh, you still need to see them. Well, actually, you need to, here, Perry.
Mr. Russell, would you